The Honorable the Deputy Speaker.
Almighty God, we give thanks to you, the Creator of the universe, and humbly beseech you to direct and prosper the deliberations of the members of this House, here assembled for the advancement of your glory and the trust and welfare of the people of Trinidad and Tobago. Grant that peace and happiness, truth and justice may be established among us for all generations. Amen.
Announcements by the Deputy Speaker.
Honourable members, I have received communication from 1. Mrs. Glenda Jennings-Smith, MP, member for Toko Sandigrandi, who has requested leave of absence for the period September 12th to September 16th, 2019. And from the Honourable Kamla Prasad-Bisesa, SC, MP, member for Siparia, who has requested leave of absence from today's sitting of the House. The leave which the members seek is granted. Honourable members, correspondence has been received from the President of the Senate, dated September 12th, 2019, which states as follows. Dear Deputy Speaker, change in membership of Joint Select Committee. At sitting held on Wednesday, September 11th, 2019, the Senate agreed the following resolution, and I quote, be it resolved that the Senate agree to appoint Mr. Daniel Duque in lieu of Mr. Gavin Simonet on the Joint Select Committee appointed to consider and report on the Miscellaneous Provisions Local Government Reform Bill 2019. End of quote. Accordingly, I respectfully request that the House of Representatives be informed of this decision at the earliest convenience possible. Yours respectfully, Senator the Honourable Christine Kangaloo, President of the Senate. To the announcement, condolences on the passing of Dr. Linda Babulal, former Member of Parliament for Barataria Sanwan and President of the Senate. Honourable members, as you may be aware, Dr. Linda Babulal, former Member of Parliament, passed away on Thursday, September 12th, 2019. Dr. Babulal served as the Member of Parliament for Barataria Sanwan in the 4th Republican Parliament from 1992 to 1995, and as the President of the Senate in the 7th and 8th Republican Parliaments from 2002 to 2007. I now invite honourable members to pay their respective tributes to Dr. Babulal, and I'll call on the Leader of the House, Member for Aruka Maloney.
Thank you very kindly. Thank you very kindly, Mr. Deputy Speaker. Mr. Deputy Speaker, today I rise to speak in tribute to a friend, a confidant, an exemplar, an icon in the local politics. So much so that when the history of Trinidad and Tobago is written, several pages would have to be devoted to the contribution made by Dr. Linda Babulal. She was a person who touched others with her compassion and her concern. Many would attest that when you left her, you left a different person, a little better person than when you first came. But that's what happens when you encounter true love and concern. It was her concern for country and her party that led her to accept the position of President of the Senate from 2002 to 2008. And by virtue of that position, 2007, sorry, and by virtue of that position, would have also been the first female to have acted as president of this illustrious republic, paving the way for the incumbent as she had paved the way for so many of us. Linda Babulal defied the ethno-political construct that is Trinidad and Tobago by becoming a full member of the People's National Movement, eventually ascending to the position of chairman of the party. She effectively stamped her own style on the party, and today is remembered by young and old alike with almost revered status, as can be seen by the outpouring on social media as one example. When we honestly ask ourselves which person in our lives mean the most to us, we often find that it is those who, instead of giving advice, solutions, or cures, have chosen rather to share our pain and touch our wounds with a warmth and with a tender hand. The friend who can be silent with us in a moment of despair or confusion, who can stay with us in an hour of grief and bereavement, who can tolerate not knowing, not curing, not healing, and face with us the reality of our powerlessness. That is a friend who cares. For me, for us in the party that is the People's National Movement, Linda Babulal was one of those persons. I believe that every time we make the decision to love someone or something as much as Linda loved us and we loved her, we open ourselves to great suffering because those we most love cause us not only great joy, but also great pain. The greatest pain, Mr. Deputy Speaker, comes from leaving. When the child leaves home, when the husband or wife leaves for a long period of time or for good, when the beloved friend departs to another country, or when, sadly, that person dies, the pain of the leaving can tear us apart. And yet, if we want to avoid the suffering of leaving, we will never experience the joy of loving, because love is stronger than fear, life stronger than death, hope stronger than despair. We have to trust that the risk of loving is always worth taking, and we believe Linda took the risk of loving her country and her party. Through it all, she kept us in check. Her wise counsel as Senate President was often enough to soothe the frayed nerves of the government and the rampaging onslaughts of the opposition. Even prior to her holding that position, she demonstrated an immense capacity to reach those particularly at the lower strata of society, both as Member of Parliament for San Juan Barataria and in the ministerial portfolios of health and social development. Today, as we gather in this place to pay tribute to one who once sat amongst us, we say, rest well, dear friend, for you have fought a good fight. You have finished your course, and you have kept the faith. You may be fallen, but you will never be forgotten. Your watch has ended, but your life has just begun. Mr. Deputy Speaker, there is a song which may be familiar to some of us with lyrics that say, persons come into the fiber of our lives, and then their shadow fades and disappears. But all I ask of you is to remember me as loving you. We in the PNM and in the government of Trinidad and Tobago give the assurance that we will not allow Linda's shadow to fade and disappear. We will remember how she loved her country and her party and her family, and we will recall always with humility how much she loved us. On behalf of a grateful party, on behalf of a grateful country, on behalf of a grateful government, and on behalf of a grieving party, I offer sincerest condolences to her husband and her children and her wider family, and pray that the God of consolation will provide them with the strength needed at this time. Mr. Deputy Speaker, eternal rest grant unto her, O Lord, and may she rest eternally in peace. Thank you, Mr. Deputy Speaker.
I will now call on opposition member for Caroni Central. Caroni East, my apologies. Caroni East.
Thank you, Mr. Deputy Speaker. I rise today on behalf of the opposition United National Congress to pay our deepest respect to the late Dr. Linda Babulal, an esteemed former member of both the lower and upper houses of our great parliament. Linda, who sadly passed away on Thursday, September 12, 2019, after a period of illness. Mr. Deputy Speaker, it was famed world leader and freedom fighter, the late, great Nelson Mandela, who once said, and I quote, "What counts in life is not the mere fact that we have lived. It is what difference we have made to the lives of others that will determine the significance of the life we lead." This is undoubtedly could be said of Dr. Linda Babulal, who truly made a tremendous difference to the lives of the citizens she interacted with over the course of her long career as first a medical doctor and later a politician. Dr. Babulal was first a medical doctor who worked in both the private and public sectors of Trinidad and Tobago. After she entered politics, as we all know, she served as the PNM's Member of Parliament for the Barataria San Juan constituency from 1992 to 1995. During that time, she also served in the cabinet of the late Prime Minister Patrick Manning as a Minister of Health and then Social Development. She then went on to be the first female chairperson of the People's National Movement, and then the first woman in our nation's history to hold the post of President of the Senate of both the 7th and 8th Republican parliaments from 2002 to 2007. During that period, she had the further distinction of being the first female to act in the post of President of the Republic of Trinidad and Tobago. She was also known for her significant volunteer work in the areas of national health and women's development. Dr. Babulal attended Manitoba University, then the Royal College of Surgeons and Physicians in Dublin, Ireland, with her husband, Michael, and after graduating, returned to Trinidad and Tobago to do her medical internship. I had the distinct pleasure of first meeting Dr. Linda Babulal in 1975 at the pediatric ward of Port of Spain General Hospital, when we both worked as young doctors in different specialties. And thereafter, we shared a very warm and enduring, cordial, professional relationship. I was always impressed by her dedication and her compassion to her patients, her tremendous work ethic, and especially her grace and dignity. When she was President of the Senate, both Senator Mark and myself, as well as other senators, we served as opposition senators. We were completely impressed by her determination to execute her duties with her trademark dignity, humility, grace, fairness, and judiciousness. And to this day, she stands out as exemplary and unparalleled in that crucial role as a guardian and overseer of our sacred chamber of democracy. The great British Prime Minister, Sir Winston Churchill, once said, "We make a living by what we get. We make a life by what we give." These are fitting words to describe the legacy of Dr. Linda Babulal to this august chamber, and indeed, our nation as a whole. For she will best be remembered by her commitment to freely giving of her great skills, wisdom, and talent to our country and our national development through her dedicated, virtuous public service. It is truly something we can all seek to emulate and indeed be inspired by, especially in these current times when our nation continues to seek exemplars in its truest form. On behalf of the Opposition United National Congress and our opposition leader, I therefore wish to extend our deepest condolences to Dr. Linda Babulal's husband, Dr. Michael Babulal, her children, grandchildren, and other family members, as well as her loved ones, friends, and colleagues on both sides in both politics and medicine. May the good Lord comfort her family and us all at this time of grief. May the great life she lived always inspire us for generations to come, and may her beautiful soul rest in eternal peace.
Thank you, members. Honorable members, I too would like to pay tribute to Dr. Linda Babulal. During her tenure in the House of Representatives, she served on the Committee of Privileges and several special select committees. Whilst in the Senate, she served on the Statutory Instruments Committee and the Committee of Privileges. Dr. Babulal was the first female president of the Senate and the first female to act as the President of the Republic of Trinidad and Tobago. The foregoing accomplishments are indeed a testimony of the fact that she, like many other women in our country, succeeded in breaking the glass ceiling. During the time she served as an elected member, Dr. Babulal demonstrated an unwavering passion towards humanitarianism. Examples of this are evident in her contribution to the House of Representatives on the Corporal Punishment Amendment Bill 1994, the Young Offenders Detention Amendment Bill 1993, and the Motion on Old Age Pensions of 1994, among others. Dr. Babulal was also passionate about philanthropy and engaged in charitable work with a number of charitable organizations. In addition, she also assisted persons who suffered with the illness of addiction and was actively involved in the New Life Ministries Drug Rehabilitation Center of Mount St. Benedict. She also gave a voice to women's issues, particularly in the realm of decision-making, through her membership in the St. Anne's Business and Professional Women Association and during her participation on many radio programs and other forums. I therefore take this opportunity to express my deepest condolences to her husband, Dr. Michael Babulal, her 5 children, and the rest of the Babulal family during this time of mourning. I pray that Almighty God grants them the solace, comfort, and strength during this time of bereavement. We will forever be grateful for Dr. Babulal's contributions to the Parliament of the Republic of Trinidad and Tobago. I now ask that we stand and observe a minute silence in the mark of respect. May her soul rest in eternal peace. Honorable members, the clerk is directed to send an appropriate letter to the family of the late Dr. Babulal.
Bills brought from the Senate, petitions, papers.
Minister of Finance.
Mr. Deputy Speaker, on behalf of the Minister of Finance, I have the honor to lay paper number 1, the report of the Central Bank of Trinidad and Tobago with respect to the progress of the proposals to restructure CLICO, BAT, and CIB for the quarter ended June 30th, 2019. Thank you very kindly, Mr. Deputy Speaker.
Minister of Community Development, Culture and the Arts.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, I have the honor to lay the following paper, the ministerial response of the Ministry of Community Development, Culture and the Arts on the 17th report of the Public Accounts Enterprises Committee on the examination of the audited accounts, balance sheet and other financial statements of the Export Centres Company Limited for the financial years 2008 to 2011.
Reports from committees, Prime Minister's questions.
Member for Couva South.
Thank you very much, Mr. Deputy Speaker. In light of the decision of the government to cancel the US $71.7 million contract between China and, forgive my Mandarin, Deputy Speaker, Jesuba Group International Engineering Company and the Housing Development Corporation, can the Acting Prime Minister inform this House of all penalties accruing to the government and/or HDC arising out of the said cancellation?
Honorable Prime Minister.
Thank you, Mr. Deputy Speaker. I'm advised that the HDC and the China Gezhuba Group International Engineering Company are currently in discussions in an effort to arrive at a mutually satisfactory resolution to the contract. As a result, there are no penalties accruing at this time.
Until Couva South.
Thank you, Mr. Deputy Speaker. Can the Acting Prime Minister inform this House whether an advance payment or sum was issued on this contract over $500 million to the taxpayers of Trinidad and Tobago?
Mr. Acting Prime Minister.
Just 1 second. Mr. Deputy Speaker, I'm advised by the Minister of Housing that no advance payment was paid.
Supplemental, Couva South.
Can the Acting Prime Minister confirm that the framework agreement for this $500 million contract was signed in July of 2018 by the then Minister of Housing, who at the time was the Prime Minister of Trinidad and Tobago, Dr. Keith Rowley?
Acting Prime Minister.
Mr. Deputy Speaker, I'm not privy to those details.
Couva South, supplemental.
Supplementary question.
Thank you, Mr. Deputy Speaker. Can the Acting Prime Minister state whether this contract for over $500 million was vetted by the Attorney General of Trinidad and Tobago?
I will not entertain that question at this time, member. Supplemental, member for Pointe-a-Pierre.
Thank you, Deputy Speaker. To the Acting Prime Minister, based on his first response of the penalties at this point not being accruing, could the Acting Prime Minister state in the contract what would that penalty be if no proper, no positive negotiations have been concluded?
Acting Prime Minister.
Mr. Deputy Speaker, I'm not privy to those details at this time.
Member for Couva South, final supplemental.
Can the Acting Prime Minister inform this House whether this contract for over $500 million was approved by the Cabinet of Trinidad and Tobago?
Acting Prime Minister.
Mr. Deputy Speaker, the framework agreement was approved by the Cabinet.
Member for Couva South, question number 2.
Thank you, Mr. Deputy Speaker. Given that 16,523 Venezuelan nationals were registered through the government's registration and migration process, can the Acting Prime Minister inform this House as to the number of persons who have formally received their registration cards to legally work in this country for 1 year?
Acting Prime Minister.
Mr. Deputy Speaker, I'm advised that cards are processed upon verification of identity and background checks from Interpol. I'm told that 5,148 applications in total have been verified by the Venezuelan authorities and Interpol and local authorities and have been recommended for ministerial approval. So far, I'm advised that 3,091 cards have been processed and printed, and the relevant applicants have been contacted to collect them.
Supplemental member for Couva South.
Thank you, Mr. Deputy Speaker. Given the data which have been provided by the Acting Prime Minister, could the Acting Prime Minister inform this House whether the figure that he has given, if any of these individuals have found to be foul of the law by Interpol and other law enforcement agencies?
Acting Prime Minister.
Mr. Deputy Speaker, I've been advised that out of the total number that was registered, so far, 112 have been found to have criminal records ranging from robbery, larceny, drug trafficking, and homicide.
Supplemental for Caroni East.
Could the Honorable Acting Prime Minister indicate whether he or in conjunction with the Minister of Health have done any or have adopted any procedures with regard to the early detection of communicable diseases arising from the presence of these Venezuelans in Trinidad and Tobago?
Member, I would not entertain that question at this time. Supplemental Couva South.
Thank you very much, Mr. Deputy Speaker. To the Acting Prime Minister, given the 112 individuals who you have informed this House have found to be or were found to be a foul of the law, could you provide this House with the information as to their current status, whether they are in Trinidad and Tobago or have they been repatriated to Venezuela?
Prime Minister.
Thank you, Mr. Deputy Speaker. As you know, Prime Minister's questions come at a very short time before this sitting. This is the information given to me by the Ministry of National Security, and I would advise the member to pose that as a direct question to the Minister of National Security, who I'm sure will be able to provide the detailed particulars that have been asked now as a supplemental question.
Question number 3, member for Pointe-a-Pierre.
Thank you, Deputy Speaker. Can the Acting Prime Minister state the specific terms and conditions of employment of Ms. Arlene Chow as Interim CEO of Heritage Petroleum Limited, inclusive of all prerequisites and allowances?
Honorable Acting Prime Minister.
Thank you. I'm not sure what a prerequisite has to do with a compensation package, but I'm advised by the Ministry of Energy that the base salary for Ms. Chow in her interim appointment as the Chief Executive Officer of Heritage Petroleum Limited, the base salary is $150,000 Trinidad and Tobago dollars per month. The interim CEO is provided with a company vehicle and a driver and has a cell phone monthly limit of 1,000 Trinidad and Tobago dollars per month. The term of employment commenced on the 1st of September, and these terms will remain in effect for a period no less than 6 months.
Supplemental member for Point of Pay.
Thank you, Deputy Speaker. To the Acting Prime Minister, based on your response, could you also state if Mr. Wiley, who is the substantive CEO of Heritage Petroleum Limited, is still being compensated by Heritage Petroleum Limited as we speak?
I will not entertain that question at this time. Supplemental member for Kumutu Manzalina.
Can the Honourable Minister indicate what process was used for the hiring of Ms. Chow?
Acting Prime Minister.
Thank you very much, Mr. Deputy Speaker. I also would like to inform that I'm advised that the terms of engagement can be terminated by either party with 1 month's notice in writing. Ms. Chow, who from her curriculum vitae, Mr. Deputy Speaker, I'm being disturbed by members to the right of me. Ms. Chow, from the curriculum vitae, her CV that was published in newspapers, has 40 years experience in the energy industry and has served in many senior positions. Mr. Deputy Speaker, I'm still being disturbed by members to my right. Has served in many positions in the energy sector, including Chief Operating Officer of Atlantic LNG, which at one time was the largest LNG processing facility in the world. Has also served in senior positions in BP Alaska and also in Petrotrin. Ms. Chow has come forward at a time when someone with that sort of experience, record, and academic training was required and has agreed to serve. And as a result, Ms. Chow was selected by the Ministry of Energy and by Heritage Petroleum because of her qualifications and tremendous experience and track record. And I wish to thank, Ms. Chow coming forward in a situation where an unforeseen event could have resulted in severe trauma to the National Oil Company of Trinidad and Tobago. In an emergency, I want to thank Ms. Chow for her patriotism, for coming forward to assist the country.
Yeah, member for Point of Pay.
Thank you, Deputy Speaker. To the Acting Prime Minister, based on what you just described about Ms. Chow, are there plans to confirm her as the CEO of Heritage Petroleum Limited?
Acting Prime Minister.
Mr. Deputy Speaker, I'm advised that Ms. Chow has agreed to serve for a period of 6 months, and it is the intention of Heritage Petroleum, I am being advised by the board and chairman, that is the intention of the Heritage Petroleum Company to do an active worldwide search for a permanent CEO who would serve in due course.
Supplemental member for Couva South.
Thank you, Prime Minister. Prime Minister, could you inform this House whether at the end of Mrs. Chow's tenure, she will be paid a gratuity payment?
I will not entertain that question. Question number 4, member for Point of Pay.
Thank you, Deputy Speaker. To the Acting Prime Minister, given the appointment of a 10-member committee by the government to evaluate bids for the sale of the Guaracara refinery, which was to be completed by August 31st, 2019, can the Acting Prime Minister state if this committee has determined a buyer for the sale and/or lease of Guaracara refinery, and what are some of the key terms and conditions governing the arrangement with this new buyer?
Acting Prime Minister.
The committee has not yet determined a buyer.
Supplemental member for Point of Pay.
Could the Acting Prime Minister state how longer would the committee be reaching a decision and reporting back to Cabinet?
Acting Prime Minister.
Mr. Deputy Speaker, the committee's mandate is to make recommendations to Cabinet, and barring unforeseen circumstances, the government expects to receive these recommendations within the next week.
Question number 5, member for Naparima.
Thank you, Mr. Deputy Speaker. Can the acting Prime Minister state whether any due diligence by the Office of the Attorney General was undertaken prior to the signing of the framework agreement between China Jesuba Group International Engineering Company and the Housing Development Corporation on July 13, 2018?
Acting Prime Minister.
Mr. Deputy Speaker, I'm advised that the framework agreement did not require the Attorney General to give an opinion on the contract.
Supplemental, member for Naparima.
Thank you, Mr. Deputy Speaker. Is it the norm for state enterprises to enter into contracts in the order of this magnitude without reference to oversight by either Cabinet or the Attorney General?
Acting Prime Minister.
Thank you very much,
Hold on,
Mr.
members, please.
Deputy Speaker. Firstly, the Housing Development Corporation is a statutory authority. It is not a state enterprise. It has its own rules according to statute, and the Housing Development Corporation does have the authority to determine its own contractual affairs.
Supplemental, Naparima.
Thank you, Mr. Deputy Speaker.
One second. Member for Oropouche East. All right. I did not say anything earlier, but please. Thank you.
Thank you, Mr. Deputy Speaker. To the Prime Minister, is it the intention of your government to change this policy so that the requisite oversight will be maintained over contracts of this magnitude, and that the shareholder, as final resort, will not incur significant sovereign debt?
I will not entertain this question. Supplemental, Baracharya Sanwan.
Honourable Prime Minister, based on your last response, could you indicate to me whether the regional health authorities will be afforded the same type of authority that the HSD has, since they're both the same statutory bodies?
I will not entertain that question. Member for Naparima.
Could the acting Prime Minister state what evidence at all subsequent to the decision of the board of the Housing Development Corporation to explain the recent termination of the contract?
Acting Prime Minister.
As far as I'm aware, that matter was already dealt with by the substantive Prime Minister at a press conference.
Member for Chaguanas West.
Thank you, Mr. Deputy Speaker. Honorable Acting Prime Minister, could you explain, having regard to your statement earlier, that the HST is a statutory corporation, how do you reconcile that statement, and therefore it is entitled to its own legal approach, with the framework agreement coming before Cabinet for its approval?
Acting Prime Minister.
I think the answer to that, Mr. Deputy Speaker, is self-evident. The framework agreement came before the Cabinet. That is a fact. And the question of the detailed contract is a matter for the Housing Development Corporation in accordance with the framework agreement.
Correct.
Question number 6, member for Naparima.
Thank you, Mr. Deputy Speaker. Given that the Prime Minister is currently in Washington, D.C. for a meeting with members of the U.S. Congress, can the acting Prime Minister indicate whether the Prime Minister will be attending the 74th UN General Assembly meeting that commences on September the 17th, 2019?
Acting Prime Minister.
Yes.
Supplemental, Naparima.
Thank you. Given that the substantive Prime Minister has missed 4 UNGAs during his tenure as Prime Minister, what new considerations informed his decision to attend this year's meeting?
Acting Prime Minister.
It was considered appropriate.
Supplemental.
Could the acting Prime Minister indicate why it was considered appropriate?
Acting Prime Minister. Please, members, please. Go ahead, Acting Prime Minister.
Thank you, Mr. Deputy Speaker. Because of matters of national importance,
Supplemental, Naprimo.
As far as you're aware, will the substantive Prime Minister be holding bilateral meetings with other heads of governments? With whom and what issues will be discussed?
Acting Prime Minister.
Mr. Deputy Speaker, I am not privy to those details, but it is quite normal and natural when heads of state and heads of government go to these international meetings and meet in these international forums that there would be discussions of a mutually beneficial nature.
That's the end.
Urgent questions.
Member for Barataria Sanwan.
Thank you, Mr. Speaker, Mr. Deputy Speaker. To the Minister of Health, having regard to reports of a rat infestation at the San Fernando General Hospital, can the Minister indicate whether disciplinary action will be taken against a person or persons with responsibility for taking preventative measures?
Minister of Health.
Thank you very much, Mr. Deputy Speaker. If responsibility can be traced on individual or group of individuals that are responsible for this, the answer is definitely yes. Action will be taken by the board following proper HR and IR policies and procedures. Thank you very much, Mr. Deputy Speaker.
Supplemental, Barataria Sanwan.
Minister, could you indicate whether there is a performance appraisal system for these employees, and what was the performance appraisal, if you do have it?
Thank you. Yes, as you know, there are performance appraisal systems, and I will tell the country this now, and I say it with no pride. I visited one of our departments recently, Central Sterilizing Department, and found out that a piece of equipment that was needed since 2012, 3 years under your administration and 4 years under mine, that people could not get a simple piece of equipment because people along the line under 2 administrations for 9 years did not do their jobs. Do I hold a minister responsible like yourself? The answer is no. Do I hold myself? But we are the ones who get blamed in the public domain. So you have appraisal systems. But the question is there the fortitude and will of supervisors to use these systems? You know, for example, one doctor, Eric Williams, gave all his colleagues 35 out of 35. Every single doctor got 35 out of 35. And you and I know, as former minister and current minister and former chairman, what goes on in the system. But who gets the blame? Are you supposed to walk around and check every CSE piece from 2012 to 2015? Am I supposed to do it? There are performance appraisal systems, but the willingness to use it is the issue that I am addressing with boards, because it means mashing toes. It means breaking up relationships, because everybody related to somebody. Everybody is friend with somebody. So you could have the best performance appraisal systems. It has taken 9 years, 3 years under you, 4 years under me, to get a piece of equipment. 7 years. 7 years under 2 administrations to get a piece of equipment. That is not the board's fault. It's not the minister's fault. It's not even the CEO's fault. Because when you trace the chain of command, there's so much responsibility to be placed on individuals who hold positions. So when the Prime Minister speaks to this country, he is right. Thank you very much, Mr. Deputy Speaker.
Supplemental, Member for Proceed.
Thank you. Minister, in view of that, what you have just indicated, would the minister see it fit to reassess the performance appraisal systems to reflect a true performance system? Would you take that responsibility?
Yes.
Minister Fell.
I will take it. But the question is the operationalization. It is people, it is supervisors, it is chiefs of staff who have to administer the appraisal. Not the minister. But you and I are crucified. Every Minister of Health is crucified. But who filled out the appraisal system that exonerated that individual filling the post that for 7 years they couldn't get a piece of equipment into a central sterilizing unit. 7 years. You could have the best appraisal system on paper, but unless people are willing to be unpopular and take hard decisions for the benefit of patients and taxpayers, the best appraisal system will simply not work. And you know that, and I know that. We were both faced with it. Thank you very much, Mr. Deputy Speaker.
Cook, member for Couva South.
Thank you very much, Mr. Deputy Speaker. To the Minister of National Security, given the recent statement by the Trinidad and Tobago Police Service, which warned teachers and parents to be on the alert as Zessa pills were being circulated in the nation's schools, can the Minister inform this House whether he has asked for an urgent investigation into this matter?
Member for Laventille West.
Thank you very much, Mr. Deputy Speaker. Mr. Deputy Speaker, intelligence has revealed that within the school system of Trinidad and Tobago, there exists the presence of and the distribution of brownies and cookies which are infused with marijuana, molly or ecstasy, known locally as Zessa pills, which are a breakdown of the crystals of the ecstasy and compressed in a capsule, are also in existence and circulating in the system. So far, these cookies and brownies have been seized by law enforcement at teenage parties and have been sent to the Forensic Science Center for analysis. The results are impending. The Commissioner of Police is liaising with the Ministry of Health, and action is being taken to ensure that all substances detected in Trinidad and Tobago that are not already in the schedule of the Dangerous Drugs in the Dangerous Drugs Act will be so put, and the Commissioner of Police and the government of Trinidad and Tobago is taking this opportunity to urge parents to be particularly vigilant, as these dirty and dangerous and nasty substances could quite easily be disguised and are being disguised in all forms of candies that are particularly attractive to children. We also urge children to think carefully and to do the safe and the right things.
Supplemental member for Couva South.
Thank you, Mr. Deputy Speaker. Given what the Acting Minister of National Security has just advised the House, is the Minister willing to inform this House how many schools and in which education districts the drugs have been circulating, or these Zessa pills?
I am very willing but unable, because that information is not now available to me, Mr. Deputy Speaker.
Supplemental member for Couva South.
I know that the member for Laventille West is the acting minister, but I don't know if he's willing to share with us whether the Ministry of National Security has been actively engaging the Ministry of Education as it relates to a sensitization policy in the respective primary and secondary schools throughout Trinidad and Tobago.
Given that this government has taken and will continue to take a whole of government approach, that is elementary, and most certainly that will be done. I might take the opportunity to say that we have already scheduled ecstasy and crystal meth as illegal in the Dangerous Drugs Act. Thank you, Mr. Deputy Speaker.
Member for Carney East, next question.
Yeah. to the Honourable Minister Bell. Having regard to reports of the same rat infestation at the San Fernando General Hospital, can the Minister state whether the lives of staff and patients at the San Fernando General have been endangered as a result of this infestation?
Thank you very much, Carney East, and I'm sure you and I share the same concerns for staff and patients. I can tell you that the area that had the problem with rats is a warehouse area far removed from clinical blocks and so on. So patients are under no direct threat. What we are doing is making sure all the few number of workers who work there, they will be tested and so on. But to further ensure the safety of all concerned, even these supplies like paper towels and so on, it wasn't drugs, huh? No drugs were stored there. It was things like paper towels, dry goods. They will be sanitized. It was always the protocol to sanitize from warehouse to wards, but that will be stepped up in this particular case. So I can tell you there is no immediate danger to either patients or staff. It was a warehouse area for dry goods far removed from the actual clinical areas. Thank you very much, Mr. Deputy Speaker.
Supplemental member for Caroni East.
Minister, thank you for that answer. But is there any other mechanism that you have used to determine whether that infestation or rats have moved across to the other buildings as a result of this?
Thank you. And that is a very good and reasonable question to ask. So what we have done, we have sent in public health to do a total examination of the entire facility now to make sure that the rats did not migrate to other parts and so create a bigger problem. So that has been actively pursued via public health.
Supplemental, Caroni East.
Appreciate the Minister's answers. Minister, is there any procedure that you will use to establish whether any person within the hospital system has developed any of the 6 diseases that can arise from the rat infestation, like leptospirosis and meningitis, etc.?
Minister of Health.
And again, that is a very valid concern. And as I said in the body to your first supplemental, we will be looking at all those employees who have direct access for especially things like leptospirosis, meningitis, other diseases. So the answer is yes, everything. Thank you very much, Mr. Deputy Speaker.
Questions on notice, questions for oral answer.
Leader of the House.
Thank you very kindly, Mr. Deputy Speaker. Mr. Deputy Speaker, there are 3 questions for oral answer, and we'll be answering all 3. Thank you. Sorry, there are no written questions for answer.
Member for Faizabad.
Deputy Speaker, question number 248 to the Minister of National Security.
Acting National Security Minister.
Thank you very warmly, Mr. Deputy Speaker. Mr. Deputy Speaker, the Trinidad and Tobago Prison Service is guided by and adheres strictly to the Maternity Protection Act, Chapter 4557 of the laws of Trinidad and Tobago.
Supplemental, Faizabad.
Thank you very much, Minister, for that response. This question actually arose from an incident where an employee was retired by the Public Service Commission, and the matter is still ongoing. Yep. The question is whether the policy in place is treating or will prevent that from happening again.
Minister.
In accordance with the law, as I have just described it, and we are all deemed to know the law, but in accordance with that law, the prison service would permit an employee to proceed on maternity leave for a period of at least 6 weeks before the due or confinement date, so-called in the law, and another 8 weeks or so thereafter. If the employee wishes to enjoy the use of her vacation leave, thereafter, an application is made and it would ordinarily grant such leave in those immediate circumstances. I thank you, Mr. Deputy Speaker. I stress her.
Members, question number 252. The member has asked for it to be deferred for when she attends the next sitting. Question number 255. Member for Faizabad.
Deputy Speaker, question number 255 to the Minister of Works and Transport.
Minister of Works and Transport.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, the Drainage Division, under the program of upgrade and existing pumps and gate inventory, embarked on the procurement process for the execution of 4 projects in this financial year, one of which is the upgrade of the gate structures at St. John's. The scope of this project is for the upgrade of the 7 existing gates, which NIDCO is responsible for procurement. Tenders were closed on August 7th, 2019, and the contract was awarded on September 6, 2019. Work is expected to commence by the end of September 2019. I thank you.
Proceed.
Personal explanations.
Member for Oropouche East.
Thank you so much, Mr. Deputy Speaker. Mr. Deputy Speaker, with reference to the report of the Committee of Privileges allegation of threatening words dated June 18, 2019, and pursuant to the recommendation therein and without prejudice to my legal matter, I extend an apology to the House and the member for Laventille West for the words deemed threatening. I thank you, Mr. Deputy Speaker, for your cooperation in this matter.
Please, members. No. Members, please. Members. First of all, Couva South, you know my stand with regards to disturbance when you are not in your seat. Those disturbances are not allowed. And I definitely will not be tolerating when you are not, or any members, as a matter of fact, which are not in their respective seats. All right, members, let's proceed.
Public business, government business, bills second reading.
The Attorney General.
Thank you, Mr. Deputy Speaker. I beg to move that a bill entitled An Act to Amend the Sexual Offences Act, Chapter 1128, be now read a second time. Mr. Deputy Speaker, I'm very pleased to be the mover of this particular bill on this occasion. This law is intended to strike at the heart of criminality in its most devious and wicked form. The most vulnerable of people in our society find themselves the subject of this particular law, Mr. Deputy Speaker. And it is a matter of note that our Sexual Offences Act, Chapter 1128, really became a law of first focus and clarity in 1986 by virtue of Act number 27 of 1986. It was that particular law, Mr. Deputy Speaker, that allowed Trinidad and Tobago to codify the sexual offences in a more precise form. In particular, to put into context the law as it relates to rape, grievous sexual assault, sexual intercourse with mentally subnormal persons, procuring the defilement of persons, the concept of prostitution, the concept of people who live on the proceeds of prostitution, taking us quite properly into the precursor to trafficking in persons and the abuse of persons, taking us into the realm of how we treat with our children, which of course was the precursor to the Children's Act and children's legislation, which we are now so proud as a country to have on the laws of Trinidad and Tobago. This law was amended in 1994, and then again in the year 2000, and then in terms of consequential amendments in 2012. In the year 2000, Mr. Deputy Speaker, we saw some important improvements in the law. Then Attorney General Ramesh Lawrence Maharaj came to the Parliament in 1999 and offered a suite of improvements, including the concept which dealt very strenuously with matrimonial rape, including as well the introduction of a new part to this law, which is the central focus of this bill, and that was Part 3, notification requirements for sex offenders. By virtue of the proclamation of the law, that 1999-2000 exercise by Attorney General Ramesh Lawrence Maharaj, we saw Part 3 of the Sexual Offences Act come to life. Part 3 is the position in law which says how persons are to be liable for notification requirements, how they are to be calculated in terms of time frame for notification requirements, how those persons are to present themselves, what information is to be given, what notification requirements are given in certain circumstances, for instance, where there is temporary detention or having left the jurisdiction, and then what the offences are for persons who fail to actually present themselves. What's quite interesting is that this law in the year 2000, as it came onto the books in Trinidad and Tobago, this law required a person who was convicted of a sexual offense to find himself, pursuant to Section 34A of the existing law, a person shall be subject to the notification requirements where he has been convicted of a sexual offense and he has been sentenced to a term of imprisonment, or where the term of imprisonment was commuted, that is lessened, or convicted of an offense but not dealt with for the offense. That person who was convicted was subject to the court indicating by way of an order on the passing of sentence or dealing with the matter, the court was to specify the time which the convicted person shall be subject to notification requirements. And then they went into what the requirements were. A person would be responsible for an indefinite period of supervision, for 10 years, for 7 years, for 5 years. The law then went into the permutations and combinations for consecutive sentencing, etc. And the law required in Section 34B that a person who is subject to notification requirements shall, listen to this, within 14 days of his sentence or the commuting of that sentence, as the case may be, or being dealt with, notify the police in the local area of the following information: his name, home address, date of birth, etc. Let me repeat that. The current law, as it has stood on the books of the Parliament for 19 years, says that a person shall, within 14 days of his sentence, find himself reporting at the local police station his name, address, etc. Let me break this down quite simply. How on God's earth, when you are sentenced to incarceration, can you find yourself reporting voluntarily under threat of law to the police station? It just makes absolutely no sense. And bearing that in mind, one has to press pause for this moment and note that the law also had some glaring logical inconsistencies. Those logical inconsistencies included the fact that you're only required on a change of address or name or circumstance to find yourself before the police. There was no other regular supervision. Further, Mr. Deputy Speaker, there was no way to factor the nuances, the very important nuances of what sexual offenses look like in Trinidad and Tobago. Meaning, what if the circumstance involved the impact to victim, where the consequence of reporting could be even worse than the crime? Let's break that down into logical sense. The Sexual Offences Act, Section 4 deals with rape. Section 5 deals with incest. Section 9 treats with rape or sexual aggression towards a mentally subnormal person. The Children's Act, Sections 18 and 19, treat with sexual penetration of a child and sexual touching of a child. But the Sexual Offences Act, as it relates to incest, requires automatically that the person who is convicted of the incest, in other words then, the mother, father, brother, sister, uncle, aunt, as defined in the law, that person is to effectively be put onto a register, and then the risk of knowledge of that to the child, the victim, becomes an exponential factor. You see, the law was divorced from considerations of victim impact, considerations of psychological and sociological impact, considerations of the work as it relates to the most vulnerable, and in fact persons deemed to be vulnerable and subject to abuse. That's what a conviction is. You were vulnerable, you were raped, you were the victim of a sexual aggression, you were a victim of an offense, you're a victim under the child's legislation, the Children's Act, and you find yourself in double jeopardy effectively. Bearing this in mind, Mr. Deputy Speaker, it's now a matter of record that the Office of the Attorney General takes certain projects each year which stand outside of the regular cut and thrust of the law as it relates to hard crime. This law treats with hard crime, Mr. Deputy Speaker, but every year the Parliament record will demonstrate that we've taken particular focus on children. Abolition of child marriage, how we treat with child victims and child offenders, how we treat with the evidence in relation to that. The Parliament record in the 4 years of this government is punctuated with a specific focus on children. Where others have been too timid or not focused enough to focus on children, this government has done the opposite. This law before us, this bill before us, now comes in square focus in terms of demonstrating the proportionality of the law, in terms of demonstrating the rational connection of prescriptive measures which the law offers to a legitimate aim, in terms of demonstrating that we have not gone too far in our legislative prescription. This law must now be considered in the context of Trinidad and Tobago. And permit me to underwrite another fact of this government. We do not come to this Parliament and have not come to this Parliament year on year in our tenure talking about the United States of America, England, Australia, what statistics look like there. We come to the population and we come to the Parliament talking about the realities of Trinidad and Tobago based upon a statistical demonstration of the good, the bad, and the very ugly. Because if we can't identify what is wrong in our society, measure it, and then make legislative prescription, we are effectively spinning the proverbial top in the mud. That's why our laws for many years have not had the bite that they ought to have, whereas laws passed under this particular government have already been seen to go to work. So let's deal with Trinidad and Tobago. Let's underwrite the Section 13(2) considerations of the Constitution as we seek to derogate from Section 4 and Section 5 rights, because one can allege that the right to privacy or the right to fair process or the right to due process are in fact dealt with or abrogated by the legislative prescriptions. So what is Trinidad and Tobago? What is the law that we must prescribe, which is right for a society such as ours, to allow us, by way of a 3/5 majority, to derogate from these rights? That must be underwritten, underpinned by reference to statistics. So let's get to the statistics. Mr. Deputy Speaker, I'm able to say that certainly when we look to the publications coming from the judiciary, at the High Court and at the magistracy, number one, we note that our matters in arrears, and we're going to use the most current data that ends at 2018, July 31st, 2018. That data set will be refreshed on Monday, the 16th of September, when the Honorable Chief Justice gives his report to the country, but via the annual report. But the current data demonstrates matters pending before the court, Mr. Deputy Speaker, as disaggregated by case type and length. For sexual offences, we have 2,915 matters pending before the court. Of those matters, we have matters which are in the period 7 to 8 years outstanding, 45, 6 to 7 years outstanding, 108, 5 to 6 years outstanding, 184, 14 plus years, 2. Let's put that into context. A victim of a rape, a victim of a sexual offense, somebody who is accused, who is in an equal jeopardy, statistical demonstration here reveals that we have people waiting for the determination of their matters for over 14 years. Year after year, month after month, making the trek to the magistrate's court in the preliminary inquiry or the High Court before the assizes to be violated all over again
every single time. But, Mr. Deputy Speaker, even though the number of first hearings and the number of cases disposed of in the High Court and in the Magistrates' Court have consistently gone up every year, even though the dispositions have gone up every year, Mr. Deputy Speaker, if we look at sexual offences dispositions at the Supreme Court, 52 matters in 2015, 2016, 44, but 2017, upwards to 69. And as at 2018's old figure, 65. The numbers have gone dramatically up since then. Dispositions are happening faster. But, Mr. Deputy Speaker, what has definitely demonstrated its position here is that the matters don't go fast enough. That's the first limb of statistical points. But let's go to the relevant aspects of the most vulnerable, Mr. Deputy Speaker. When we look at the vulnerability, let's freeze frame for a moment on the issue of children. Let's go to the Children's Authority, Child Sexual Abuse. It's a publication coming from them, May 18th, 2015 to October 31st, 2018, and what the data there demonstrates. Mr. Deputy Speaker, we're looking at the alleged perpetrators of abuse to children. 21.5% the father, 40.5% the mother. Perpetrators not identified, 16.1%. Listen to the age ranges of reported physical abuse, and then we'll get to sexual abuse. 0 to 11 months, 2.1%. 1 to 3 years, 13.9%. 4 to 6 years, 18.9%. 7 to 9 years, 19.6%. 10 to 13 years, 24.1% reported to the Children's Authority. Let's get, Mr. Deputy Speaker, to the age ranges of sexual abuse. 0 to 11 months. A child not even 1 year old, 0.4%. 1 to 3 years, sexual abuse, 5.4%. 4 to 6 years in the innocence of a child's life, 11%. 7 to 9 years, 12.6%. 10 to 13 years, pubescents finding themselves, 24.3%. 14 to 15 years, the unsure years of a teenager's life, 25%, Mr. Deputy Speaker. The Children's Authority tells us, Mr. Deputy Speaker, further, that the gender of sexual abuse is skewed 84.9% girls, 15% boys, 2015. 84.1% girls, 15.8%, 2016. 81.8% girls, 17.2% girls, 2017-2018. The distribution of reports across Trinidad and Tobago demonstrate that this is a phenomenon right across Trinidad and Tobago. Rural, urban, centers, call it what you will. The evidence is that abuse happens across Trinidad and Tobago. Let's get to the Children's Authority global figure. Data presented provides a preliminary analysis of the cases of children in need of care and protection brought to the attention of the authority, period May 18th, 2015 to April 30th, 2018. Listen to this. During this period, there were 14,581 cases of children in need of care and protection. Let me repeat that. 14,581 cases of children in need of care and protection. What does this law propose? This law proposes a form of protection, a balanced and nuanced approach,
looking at the modern issues of penological assessment, of the principles of sentencing, retribution, deterrence, rehabilitation, looking at the statutory prescriptions alongside sentencing guidelines. And this government says, we say in this government, that there is a gross inadequacy in the Sexual Offences Act as it has stood on the books of Trinidad and Tobago for 19 years. Why do we say that? Let's turn to one more statistic. The judiciary has confirmed the following. Number of persons convicted in the period 2000 to 2019, number of persons convicted for sexual offenses and who really ought to be on this register. Number of persons convicted, magistracy, 1,461. High Court, 232, for a total of 1,693. Number of persons ordered to register in the sex offenders registry at the magistracy, 0. At the High Court, 0. For a total of 0. We say when you unearth the very ugly of Trinidad and Tobago, the reality of what our country looks like, the assessment of the law of the Sexual Offences Act Part 3, 34A onward, when you disaggregate that information, it shows that the law just did not work and nobody was paying attention. Fortunately, through the combined effort of the Office of the Prime Minister, the Minister with responsibility for gender affairs, the very hard-working and capable member for Tobago East, fortunately, with the Minister of National Security, previous, the member for Point Fortin, and present, the member for Port of Spain North, St. Anne's West, fortunately, with the member for St. Joseph, the Minister of Health, fortunately, with the capable and aggressive assistance of the member for Laventille West, and the member for, with responsibility for education, the member for Arima, the combined effort of these government ministries have resulted in data coming forward to now give legislative prescription. So let's go into the legislative prescription. Mr. Deputy Speaker, may I ask what time precisely I must end in full time?
3:11.
Much obliged, sir.
3:11.
Not enough time to pilot a bill like this, but let me do it as swiftly as I may. Mr. Deputy Speaker, we brought the law. We brought the law and we laid a bill in the Senate. The bill in the Senate was intended to provoke, let me use that word, was intended to provoke response. We piloted the law in the Senate. We received stakeholder commentary from the judiciary, the DPP, the office of many entities in Trinidad and Tobago. And in the course of the Senate debate, we were very fortunate to receive the loud input, commendable input of many NGOs in Trinidad and Tobago. As a result of their communication, we took the opportunity in the Senate to establish a special select committee. That special select committee referred the bill into a very aggressive stakeholder commentary and revisionary approach. I will confess as the drafter of the law that we took liberty in the first draft of the law that went to the Senate to set some very strong polls. We wanted, like Canada does, to have sex offenders' passports stamped with the fact that they are sex offenders. We wanted to put every method and possible deterrent to use. We were asked by many a stakeholder to consider not going that far too quickly, and in the Special Select Committee, having met 12 times under the most capable chairman of Joint Select, now Special Select Committees, the Honorable Clarence Rambarat, I wish to pay homage to his contribution. That honorable member, together with members of the Senate, allowed the Attorney General to participate as a minister, and we went to work on 12 sessions. In that session, we were able to produce an amended bill. That amended bill is now before the House. That amended bill allowed us to bring with unanimous support, albeit that the opposition came not so willingly to the table, as the evidence before the Senate demonstrates, but the independent support was very aggressive in supporting this bill. And I'm grateful that notwithstanding the protestations of Senator Mark in particular, notwithstanding his constant protestations, that we were able to see this law brought to this House. So what does this law say? This law, Mr. Deputy Speaker, provides for a few very important positions. It's 10 clauses long. This law is the amendment in the short title to the Sexual Offences Act. It comes into operation on such a date as it may be proclaimed. Honourable members.
Members, even in hushed tones, you all are audible once I'm sitting in the chair. Please, please. You all will have the opportunity. Proceed, AG.
Mr. Deputy Speaker, today is the one day that I ask honourable members to be very somber and sober on the law before us. See, one day I ask for that. This is a solemn occasion because we get a chance to improve a law that just wasn't working for 19 years. It was not working, as the evidence has demonstrated. Very importantly, Mr. Deputy Speaker, Clause 4 of this bill says that this bill specifically says, Mr. Deputy Speaker, that this law is going to bind the state, Mr. Deputy Speaker. We put that in Clause 8 of the, forgive me, I'll find it now, I have a marked up copy. We have asked for the law to bind the state, Mr. Deputy Speaker. I'll come to that in a moment. 7. Thank you, Honourable Member for Faizabad. Thank you. Clause 7. We've asked for this law to bind the state because we want to ensure that the functionaries of state can be compelled into submission and into compliance. Why? We've demonstrated, notwithstanding thousands of cases coming from the High Court, nobody went on the register. Officers of the public service need to be held accountable for their responsibilities. And we as members of the state have now said that the state ought to be specifically bound. Let's go to Clause 5. Importantly, Clause 5 introduces a suite of recommendations for amendments to the definition section, where we seek to amend Section 2 of the Act. Importantly, we have borrowed from other particular laws the reference to, heavy reference from the DNA legislation to samples, to the manner of person who ought, the identity of persons who ought to take samples, qualified persons, persons who are to be representatives of people. We've dealt with what conviction looks like. We've brought in the specific reference to intimate samples and non-intimate samples, and we have defined, at least in reference part, sexually transmitted infection to include HIV as a very important position. It doesn't exclude all other types of sexually transmitted infections, but it certainly does include HIV. Clause 6 is where we take the effort to harmonize the laws which we fixed. In our period, we've managed to say that a child is a child is a child, full stop. 18 stone cold is when you become an adult. And the last remnant of that law that needed to be fixed was, of course, the Marriage Acts, where we said that you can no longer be married if you are under 18 years of age. We next, in Clause 7, thank you, Faizabad, sought to bind the state. In Clause 8, Mr. Deputy Speaker, we have sought to improve Section 26 of the Act. Section 26 of the Act is where we treat with what was an inadequate reference to definition, because we were making reference to parts of laws. We were dealing with the entire Act. We were dealing with the Children's Act as to certain parts. And what we said instead, thanks to stakeholder injection, thanks to the Office of the Attorney General and its technocratic work in particular, we sought to schedule out what the offences will be. Effectively, those are listed in Schedule 2, Mr. Deputy Speaker. And in Schedule 2, it's to be noted that we have, of course, brought forward offences for which persons under the age of 12 years old are not liable. And we have also dealt with, in Schedule 2, further on, the information to be contained. We have dealt with, in the registrable offences at the schedule, the specific definition of offences. And let's go to what the offences that are caught and are registrable offences. What will you be brought onto the register for if there is a conviction? There are offences under the Parent Act, the Sexual Offences Act. They include rape, grievous sexual assault, incest, sexual intercourse with a subnormal person, bestiality, indecent assault, procuration, procuring defilement of a person, detention of a person, abduction of a female, suppression of brothels, persons living on the earnings of prostitution, aiding in prostitution. We've also lifted from the Trafficking in Persons Act, but we've selected out sections 16, 17, 18, 19, and 23 to deal with where there is an actual sexual aggression in trafficking in persons, not just for the economic migration suppression issue, not for the abuse of employment, but we've confined it to sexuality. We've dealt with the Children's Act, sections 9, 10, 11, 12, 13, 14, 15, 16, 18, 19, 21, 22, colleagues, 23, 24, 25, 29, 40, 41, and 42 in particular. And what we have sought to do there is to give a very specific reference to the laws that are now determined to be registrable offences. Mr. Deputy Speaker, importantly, in Clause 9, we seek to broaden the category of persons where we have mandatory reporting requirements. What do we mean by that? Section 31(1) of the Parent Law says that there is a certain class of people identified as having a fiduciary responsibility, effectively, of reporting what they consider to be sexual offences. The evidence coming before a doctor, a nurse, etc., if they fail without reasonable cause, let me repeat, if they fail without reasonable cause to refer this matter and report the matter, they are guilty of the offence of failing to mandatorily report. That exculpates somebody who may be guilty and who has come before a mandatory reporter, and that mandatory reporter is fearful of his life. It isn't an offence which doesn't have a very careful description of what the mens rea is. There is an allowance for reasonable excuse or reasonable cause. We've sought to add on the positions of a psychologist or certified mediator, a police officer, welfare, probation, social worker, the owner, manager, or employee of a nursery, daycare, school, community residence, and very importantly, guidance counselors in leadership at youth, religious, faith-based sports, recreational, or other group where there are children. So we have broadened this concept. We've preserved the exception of reasonable excuse, but we are broadening the network to say everybody must report. You must do so in protection, in particular, of children. We then go, Mr. Deputy Speaker, further in Clause 8 to amend Section 9A of the Act. We have effectively, in amending Section 9A, sought to convert it from a summary offence to an indictable offence. We've moved from $20,000 in fine and 12 years instead to $100,000 and 20 years. Why? If you are going to prevent a child from giving a statement or testify, you ought not to have the liberty of the statutory prescriptive period for a summary offence being 6 months. You should be subjected to an indictable exposure where there is no limitation. And that is a very important tool to balance the rights and protection for children. Clause 8 goes on to amend Section 31D. We've harmonized now the deletion of YTC Youth Training Center. We've moved to child rehabilitation centers or community residences which take both CRCs and children's homes. We have also cleaned up by Section 9C, Clause 9C, Section 34. Section 34, as it stands on the books, cross-references laws which were repealed in the year 2000. The reference to Sections 8, 11, and 5, those laws were repealed in sections that came in the 2000 laws and in the 2012 laws. So we've cleaned that up. Clause 10 of the Act is where we now go, Mr. Deputy Speaker, to introduce two new parts. We are introducing Part 3 and Part 4 of the law. As contained in the bill, we are in Part 3 dealing with compensation for virtual complainants in new proposed sections 35, 36, 37, 38, 39, 40, 41, 42, and 43 to 44. And then in Part 4, we introduce a National Sex Offender Registry. These are sections 45 straight through till we get to section, as I get to the end of the bill, section 68 of the law. These are new proposed sections. So let's deal with this in its divisible parts. Let's deal with the first Part 3. In Part 3, we are effectively allowing for compensation of virtual complainants. The law as it stands right now was a nonsense. It is the current law that you would only have a person subjected to medical examination when they are convicted, not charged. We've given the statistics. 14 years you're waiting on conviction. Obviously, you're going to break the chain of causation from a liability point of view, because 14 years later, if you find person charged, now convicted with HIV, how do you relate that back to an HIV infection of the virtual complainant 14 years later? There would have been events that would have obviously happened in the 14 years in between. Second factor is that it did not contemplate the position of the immediacy of the requirement. A, upon being suspected, and B, upon being charged, and C, upon being convicted. And what we've done in these sections is to rationalize the logistical approach to this. If you're charged, immediately upon charge, the virtual complainant may be examined if there's consent given. The suspect will be examined compulsorily and involuntarily if necessarily, and with the use of force, such reasonable force as is required, taking intimate and non-intimate samples. We allow for second testing in the event of a negative screening. We allow for the virtual complainant to change his or her mind, because the virtual complainant is caught in a cycle where the virtual complainant may be fearful or traumatized still at the incident, but 6 months later, as the law prescribes, may voluntarily say, look, I'll take the test, and then allow for another voluntary testing in the event of negative screening. The fact is, we have also now gone into the realms of compensation. Now, the Criminal Injuries Act allows for compensation. The general law allows for compensation. And what we have done here, Mr. Deputy Speaker, apart from allowing what the existing law looks like, we have said that there will be a case, and it's to be found in the new proposed section 42, that where somebody is charged, that if the virtual complainant is deemed on a balance of probabilities to have contracted a sexually transmitted infection, that virtual complainant can bring the matter before court before a conviction, and on the civil standard, on a balance of probabilities, ask the court to award compensation. We then allow for it in the case where there's an actual conviction. We then specifically make sure that we have introduced the preservation of further compensation by other laws and also under the Criminal Injuries Compensation Act. So we allow for compensation prior to conviction, balance of probabilities with a safeguard of a prescriptive period of 4 years. We allow for further compensation. We allow for the other laws to operate in tandem with this particular law. Of course, in these sections, we prescribe the management of the samples, the manner in which intimate and non-intimate samples ought to be treated. They are borrowed very heavily from the DNA law. The regulations are preserved to be prescribed under this law. We allow for regulations to be promulgated subject to negative resolution. As you know, this government was pleased to introduce the DNA regulations, which are in fact regulations done on the first occasion by affirmative resolution. We debated these laws, and here we have ample precedent for it. Let's get to Part 4, Mr. Deputy Speaker. This is the National Sex Offenders Register. I'm going to put this in very simple terms because the law is prescriptive and one can easily read the law to gain it. Let's break it down into its elemental pieces. Effectively, we are saying that this law applies to citizens of Trinidad and Tobago, residents, persons who are deported. The law applies to territoriality and extraterritoriality. If you are convicted in a court elsewhere and you find yourself back before Trinidad and Tobago, or it happens elsewhere and it's deemed to happen and then you actually return, other than by way of deportation, you are caught by this law. We say that it applies to people that can be subject to prisoner transfer, as we have laws to deal with the transfer of prisoners, persons who are deported, and people who are in that first limb of territoriality and extraterritoriality. We then deal with disaggregating the law as it relates to hard offenders, persons who are offenders who are themselves subjected to or operating under mental difficulties, mentally subnormal. It's not quite the term used, but we've had to use some of the archaic terminology until the law revision goes to work to improve the language of our laws. And we have very specifically dealt with the concept of the child victim and child offender. We excuse child offenders from the application of this law. We do not apply it to child offenders. Why? Our Family and Children Division Bill, our miscellaneous provisions laws, our 19 amendments to law done under the FCD law in 2016, our 23 amendments done to the law under the miscellaneous provisions bill in 2017. That combination of laws, that mammoth amount of work that this government has done in harmonizing the laws has caught that. We have anonymized child matters in the children's court. We have opened 2 children's courts. We have children's matters happening. This law is up and running. And dare I say, I met with representatives from the United States of America, their government. They are intrigued and interested in replicating Trinidad and Tobago's success in the rest of the Caribbean. And they are on mission analyzing the work that this government and this judiciary have performed and completed to replicate the models. The government of Barbados right now is cutting and pasting what we have done in Trinidad and Tobago. And we are very pleased to say that we have done an excellent job, Mr. Deputy Speaker. Mr. Deputy Speaker, we deal with the fact of the logistics. The registrar of the court must inform the Commissioner of Police. The Commissioner of Police must maintain the database. The Commissioner of Police, in maintaining the database, must maintain its accuracy. We provide safeguards which include the right of any person to approach the court, have a matter expunged, have a matter reconsidered, have a matter not go onto the register in the event that there's an appeal. There's a pause in that circumstance. We say as well, Mr. Deputy Speaker, that the register, even though populated at the TTPS, and even though the TTPS has an obligation to create a web interface, that does not go public unless the court says that it is to be made public. Why? That is taking care of Trinidad and Tobago incest victims, persons who may have more damage by publicity than the publicity itself in deterring or managing the incidents of crime. We allow specifically, Mr. Deputy Speaker, for that due process to be preserved in the legislation, Section 65, etc., adding to the proportionality of the law. We allow for review at any point in time. Very importantly, we have incorporated into this law the need for mental assessment at each stage of the equation. We demand in the law that the court must tell the victim, tell the family, notify the prisons of any event. We say that the prisons, prior to the release of the offender, must conduct at 4 months and 2 months and then weeks before the steps of ensuring the reporting to family of the imminent release, the mental assessment by way of psychiatric and psychological assessment, the reference to the court, the right to the victim, the right to the offender, the victim impact statement. We tell the court, before the court expunges or decides not to make public a register, we've set out the factors in the law which the court must consider,
you have 2 more minutes,
in very prescriptive terms, to include impact to victim, impact to family, impact to offender, psychiatric and mental health assessment, etc. Mr. Deputy Speaker, what this law does effectively is in a very prescriptive way to manage every aspect of process flow in the realm of sex offenders. What do we hope to achieve by this law? Number one, we hope to achieve through careful thought and process that sex offenders will be registered, may be subjected to public scrutiny. We look at the rights of victim, the rights of offender, we balance those processes through due process, legal requirement, and we apply first world thinking to a horrible solution that is required to be produced. I say horrible solution because this solution is on a horrible problem. So it'll never be a good position. The fact is that this shouldn't happen at all, but it does. And our evidence says so. Mr. Deputy Speaker, I commend this bill to my learned colleagues, to all members. I'm confident that we can have today a unanimous approach to this law, and I beg to move.
Honourable members, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Sexual Offences Act, Chapter 1128, be now read a second time. I recognize the member for Faizabad.
Thank you very much, Mr. Deputy Speaker, for the opportunity to contribute on this very critical piece of legislation. Sexual offenders are a menace to society, inflicting tremendous physical and psychological scars on their victims, more so when these victims are children. In fact, Mr. Deputy Speaker, looking at the news this morning on Al Jazeera, I saw there was a protest in South Africa on a rape crisis that's occurring. I just make this point to state that in some countries, sexual violence can get so far that it becomes a real societal issue, and therefore it is even more important that we address these issues right now. And I just wanted to quote, because there were many placards in that protest, and what I thought was capturing my attention, one placard said, "My body is not your crime scene," which is really what we are speaking about here. So, Mr. Deputy Speaker, this bill is therefore a very timely intervention as we grapple with increasing levels of crime, and hopefully it will be a useful addition to the tools already available to our law enforcement officers as they battle the criminals in our society. Before I go further, Mr. Deputy Speaker, I want to commend the process which has brought this bill before us today. And I speak of the improvements that would have come from the original bill that the AG mentioned. The willing participation of so many stakeholders in the consultation process, which was embarked upon by the Special Select Committee, shows the eagerness of citizens to participate in making laws that affect them. And I want to say that the more we engage the expertise, the experience, and the ideas of relevant stakeholders, Mr. Deputy Speaker, the better will be the laws we produce in the Parliament. And this obviously is a very good example of engaging that process. I want to take the opportunity as well to thank all the members of the Special Select Committee, including the government and independent senators, for their hard work. I noted the input of my medical colleague, Independent Senator Dylan Remy, who, although not a sitting member of the committee, and this is in the report, took the time to examine and fine-tune some of the medical issues in the bill. In particular, I wish to commend our members on this side, Senator Haynes, and also former Senator Ramdeen. And indeed, Deputy Speaker, I want to endorse the words of the chairman of the committee, Senator Clarence Rambarat, who I understand did a very good job, when he spoke in the Senate on the 6th of June 2019, and I quote, "I want to record our gratitude to Senator Ramdeen on his contribution to the work of this committee." I also wish to acknowledge and commend those individuals and groups, 22 stakeholders, I believe, in all, making 125 recommendations, whose time and effort ensured that the final product in front of us here today is an improvement on the bill that was originally laid. Deputy Speaker, in preparation, and I just want to say this, in preparation for my own private motion on measures to eliminate violence against woman earlier this year in this House, I and this House benefited from the willingness of many stakeholders to share their thoughts, experience, and expertise. The government would be well advised to make stakeholder consultation a habit as opposed to an exception if the country is to benefit from our deliberations in this House. And AG, I appreciate the fact that there was tremendous stakeholder consultation and input into making what will be good law. At this point, I just want to say at the outset, Mr. Deputy Speaker, that we believe that this bill has some merit and is worthy of consideration. When I perused the report that formed the basis of this bill, I noted that Senator Rambarat, in his Senate contribution on the motion to adopt the Special Select Committee report, which forms the basis of this bill, identified 7 key areas that the committee focused on. And I believe that all of these, or most of these, have been addressed by the AG in his piloting of the bill. And these were the issues of mandatory medical examinations, publication and what should be published in the proposed registry, the issue of professional assessment of offenders to identify and qualify risk, and I note here that the introduction of psychiatric and psychological assessment, which I welcome as a good addition in terms of assessing risk for offenders. The circumstances that could allow exemptions from the list, the issue of periodic reporting, and what was originally there, the issue of the entry being made in the passport of someone who was convicted for an offense relating to children. And I know that that has been struck off completely in the bill before us. And the other issue that came before the committee was the broad ambit of the requirement for registration. Mr. Deputy Speaker, the statistics presented here today by the Attorney General are very frightening indeed for a small country such as ours. And it really and truly means that we have a long way to go, and we have to do that quickly. We have to get there quickly, because a lot of the statistics pertain to children and the impact of sexual violence on children. I, at this point, would want to say, as I mentioned, we on this side believe that this bill has merit. There are, however, a few points on which we seek clarification, and I trust that the government will be happy and able to answer. For ease of reference, Mr. Deputy Speaker, I will raise my concerns and make suggestions around the relevant clauses that we believe where further elucidation will be beneficial. Before I get to clause 10, which really is at the heart of this bill, Mr. Deputy Speaker, I wish in passing to make a few observations on clauses 5 and clause 9. So clause 5 refers to definitions, and I note the introduction of some new definitions. And Honorable AG, I know you did mention sexually transmitted infection includes HIV virus, and you alluded to the fact that it doesn't exclude others. My question in this respect is that what others would be included, and whether we are going to use international standards, for example, WHO standards for STIs. Remember, for St. Joseph, you know that sometimes the definitions can vary, and you can have new STIs evolving over time and being classified as such. And the question really is whether this is going to be done by regulation and included in the regulation. So it's just something that I'm raising. Clause 9 speaks to the amendments to Section 31(1), which is to expand the categories of persons required to do mandatory reporting of suspected abuse of a child. Again, I note the thinking here in terms of widening the ambit so that those who are witnesses and so on to child abuse have the opportunity to report. And it does capture additional caregivers, categories of caregivers who may deal with children to report, in addition to retaining those already mandated to report. I just wanted to raise a point, and if you will permit me, Deputy Speaker, to refer back to the original bill and to look at. Right, so I'm just referring back to the bill which we are amending, and that's Section 31(1). And any person who has, and so on, there were 4 categories originally, and we included in some extra categories. And has performed a medical examination in respect of a minor. There's just one issue I want to throw out here for consideration, AG, of the categories that we have added. There are situations sometimes where someone might turn up for an ultrasound scan and can be diagnosed as pregnant. And therefore, the question that might arise is whether in those circumstances, the person who is performing the ultrasound is bound or mandated to report that. Because if a pregnancy is diagnosed in a child, it means that the law has been broken, that, an offense has been committed. So I just throw that out, for thought. And I note the addition of the category psychiatrist, psychologist, or certified mediator. And I welcome this addition in addition to the others. And at this point, I just want to again commend. I see there were numerous contributions to the report from the Trinidad and Tobago Association of Psychologists. But I just want to, there are two things I want to do. I want to make a plea for more psychologists to be employed in the public service, in the schools, in the health sector, the police service, and so on. We certainly would need more of those in terms of resources. But there is also another consideration which I want to raise, AG, regarding to psychologists. In the same way that medical practitioners and nurses are registered and licensed to practice, in Trinidad and Tobago, we are yet to have that licensing process for psychologists. And therefore, the issue in terms of quality control, who is properly qualified and so on, to act as a psychologist is raised. So, Member for St. Joseph, this is something that I'm hoping that you will take note of in terms of the issue of standards and licensure for psychologists as we go forward. The Trinidad and Tobago Association of Psychologists, they themselves have brought this matter to my attention, and I thought I would just raise it in the context of this bill. AG mentioned that that in the original bill that the offense is punishable, but it says without reasonable excuse. And he did mention certain situations where you can have reasonable excuse. I just again want to throw this out, and I'm sure that the new category who have been added, like the psychiatrists, the psychologists, and even medical practitioners, will sometime face a dilemma in terms of revealing information, and therefore whether this reasonable excuse would cover the professional confidentiality and breach of ethics. And perhaps maybe in his response, the AG can respond to that. So that takes me straight on to the new part 3, which is the compensation of the virtual complainants. And I go straight to section 37 in the bill before us, which is the new part 3. And I note that that there is mandatory examination of offenders charged with certain offenses, and in the bill it states rape, grievous sexual assault, incest, sexual intercourse with mentally subnormal person, sexual penetration of a child, sexual touching of a child. And these require mandatory medical examination. Absolutely no problem there. The wording, and I note that reasonable force can be used in making the arrangements for the examination. Now, but I see here the issue of make arrangements, and I'm just wondering whether in terms of make arrangements, whether the police officer should be provided some sort of guidance with regards to making those arrangements, and maybe specifying perhaps that whether it should be a police station or health facility or any other suitable facility. With regards to the use of reasonable force, I know that there's an immunity clause, which I commend, which protects the police officer or the healthcare practitioner if force has to be used. In section 37, we also provide such number of medical examinations of the person within 1 year from the date of the first medical examination. Very important, because we know sometimes the first examination might be negative, and therefore it allows the opportunity for an STI to be diagnosed subsequent, and gives the opportunity to make that diagnosis. So I think that's a very important provision, and I'm quite happy to see that provision here. So it does provide adequate space and protection of the victim with regards to these medical examinations. It does go on, however, in terms of the medical examination of the virtual complainant, and speaks about reasonable privacy. My concern here would be whether we are going to dedicate certain spaces in the health facilities and the police stations to ensure that these examinations are conducted, with privacy for the victims and for the caregivers. Section 38 speaks to medical examination of virtual complainants, and I just wanted to make a point on 38.2, and if I read section 38.2, it will become clearer. And it says a virtual complainant who does not consent to a medical examination pursuant to subsection 1 may, within 3 months of the date on which the report is made, request that the medical examination be conducted. I am hoping that the Select Committee would have thought about that, and I would be grateful if the reason for selecting that 3 months is given to us. My concern, Member for St. Joseph, is that if you allow a victim to wait 3 months, up to 3 months, to subject himself or herself for a medical examination, you're putting the victim at potential risk, because it means that time has elapsed in terms of treating if that person were to contract a sexual disease. It also provides a window of doubt, if you understand what I'm saying. It provides a window of doubt because the incident occurred 3 months ago, and now you're saying 3 months later you're coming for a medical examination. Should something be discovered 3 months later, then it might be difficult to tie that back up to the perpetrator of the crime. And I say this, I know that victims need to be protected. I understand that. I understand that the time of an incident, the psychological frame of mind may not permit an examination. Yeah, but I think that the 3 months also has some things that we need to look at, and perhaps we may want to look at a different window with regards to what I've just spoken. I suspect that the 3 months would have been to give you time, but there can be disadvantages to that, as I pointed out. So section 41 speaks to so I'm just moving on here to section 41, which is the collection, packaging, storage, and delivery of a sample. Again, I know most of these are taken from the DNA legislation, and I would want to raise the same concerns to ensure that the adequate provisions are made for proper sample collection, storage, especially some of these samples can be very temperature sensitive, and in terms of transport and security and so on. I believe many of these issues would have been ventilated in our debate on the DNA regulations. I just flagged them again. One of the things I'm concerned about, Mr. Deputy Speaker, is that at the time when the offender undergoes a medical examination and a sample is taken, now in the regulations, the information that has to be kept for the offender includes a DNA profile, which compiled from the sample taken from the offender. The concern here, I just raised it, may not be a concern, there might be a good explanation for it. But when you take the sample of the accused, who is not yet convicted, is it that you're going to do a DNA profile at that point in time? Because if the accused subsequently is not convicted, it means that you've secured a DNA profile from someone who is not convicted. So I'm just raising that point. You may want to collect the sample, but perhaps you may want to defer the DNA profiling until the person is convicted. Perhaps this is addressed in the legislation, but I didn't see it, and I'm just raising that perhaps we can provide clarification on that. So the question really was whether the DNA profiling will apply to the accused or only when convicted. And of course, with the issue of DNA profiling, again, I would want to raise the issues of the state of our forensic sciences. I know we have some challenges, and perhaps we can get an update on what is happening with the, I know the TTPS has announced that they are going to have their own forensic science department, whether there's going to be resourcing for that. And I also remember that, that a new forensic science center was promised by the government in conjunction with the Chinese government, and perhaps we can get a status update on what is happening with that. Because the evidence is that there is really a long delay, undue delay, with regards to the processing of DNA samples. And again, the Attorney General is on record saying that 15,000 DNA testing kits were en route to Trinidad in 2018, and we look forward to an update as to whether those kits are here and available for the use at the Forensic Sciences Center and elsewhere. So the other issue here with regards to, I'm still on clause 41.2, and 41.2a says that a qualified person who takes a sample from a person pursuant to section 37, 38 to 39 shall, as soon as possible, submit the sample for analysis. And again, I'm presuming that this analysis will be done in a government facility. But member for St. Joseph, I wanted to use this opportunity to raise the whole issue of the certification and registration of laboratories, both public and private, to ensure that you have accurate results, because you're making an accreditation, because you're making, you'll be making a conviction and offering compensation based on the results of these tests. And it may be conceivable that even from the public service, if you're overburdened and overloaded, that you may contract private laboratories to perform these examinations. And therefore, it is incumbent upon the state to ensure that these laboratories are properly accredited. And that is something that we need to look at in this country. I'm sure that something would have crossed your mind, but again, I wanted to, to flag that. I would go on then to Part 4 of the legislation, which speaks to the National Sex Offender Register. The AG summarized essentially how this is going to work. Our concerns here would be in terms of the resources to operationalize, but before I speak about that, I just wanted some clarification. Now, I know there would have been debate at the Senate Select Committee as to whether to have the information public versus private. And of course, the decision was taken to keep the information private for very good reasons. But I just want to bring to the attention of the House the fact that there is a ongoing debate about whether it is better for it to be private or public. And I just wanted to take the opportunity to make a few points. I mean, there have been many studies have been done on the pros and cons, of whether the registry should be public or private. And I would just take the opportunity to look at a few of these, and perhaps, for the consideration of the government in terms of whether, as the law evolves, that we may look at moving from having the register private and go public. So I differentiate here between registration, which really, registration speaks to making the information about sex offenders available to law enforcement and criminal justice agencies, and this is to facilitate criminal investigations. And then you have the issue of notification, which goes further by making information about individual sex offenders accessible, either directly, freely, or by request to individuals and organizations in the community. And And as I said, the jury is still out on this. In some jurisdictions, it works well when the information is kept private. In other jurisdictions, it's public, and they have had success as well. So just for the benefit of the public as well, some of the advantages of having a public registry. You have the advantages that the threat of notification can act as a catalyst for sex offenders to participate in treatment and comply with conditions of probation and parole, so that can be an advantage. Notification may encourage community members to report suspicious behavior, and this can suppress criminal behavior. Likewise, the presence of notification may deter future acts of sexual violence because increased surveillance leads to a greater risk of detection. It also has the advantage of being able to warn residents about a sex offender and may prevent those residents from becoming victims. This is where the information is public. And it can be a useful tool for educating the public about sex offenders, revealing specific risk behaviors and correcting false rumors and assumptions. But I know that the AG will have given specific reasons as to why we are keeping it private. And of course, we'll have to respect those reasons, especially as it pertains to children. But this is just an argument, that can be forwarded. And the disadvantages, of course, is that sometimes notification can incite excessive community fear or anger, and it can result in vigilantism, which has happened in other countries, or other criminal activity. It can create a false sense of security in communities, leading residents to conclude that they know about the sex offenders in their midst, when in fact a resident is more likely to be sexually abused by a parent, relative, or acquaintance than by a stranger. And the statistics quoted by the AG in his presentation bore that out, where a high number of sex offenders were actually relatives, family of the victims. Notification and registration lists can lead the public to believe that these registered sex offenders are the most dangerous. However, we do have to note that rape is perhaps one of the most underreported crime, and therefore this may not actually be a deterrent. So I just threw those out in terms of the arguments for and against. I take note of the fact that the government has taken a decision based on the stakeholder consultation, but I'm just saying in the future as the law evolves, is something that we may want to consider. And just to note that the evidence in Canada and Australia, and I know they just spoke about the local figures, but it's still good, to compare your own conditions with what happens abroad. And there is evidence in Canada and Australia that their registers are private and they work in the interests of law enforcement. We should note, however, that the intelligence gathering of these countries is superior to our situation at this time, and therefore keeping it private may have worked in the context of their detection rates and easier and greater deployment of resources. However, in our jurisdiction, the detection rates are low, and we often depend on public campaigns asking the public to provide information. And therefore, as I said, we may want to consider in the future whether it might be beneficial to have the public access this information. Now, Section 47 and Section 48 really gives additional responsibility and functions to the Office of the Commissioner of Police and the Trinidad and Tobago Police Service. And there are a few questions I would want to ask in this regard. We have heard from the Trinidad and Tobago Police Service in this Parliament earlier this year that they are under-resourced, and therefore the question arises, how does the government intend to operationalize these sections, the sex registry? What plans are there for training and increasing the manpower resources of the TTPS? In fact, when you may need specialized training for police officers to be able to carry out their duties properly. And will there be a separate and ring-fence budgetary allocation to maintain and protect the registry? And I make these points in light of the fact that the National Sex Offenders Register has been part of the law since 2000 by virtue of the Sexual Offences Amendment Act 2000. However, the register was never properly operationalized and as a result never populated. So really and truly the population, the country would be wondering and would be wondering as to what other plans are there to ensure that this register is maintained as expected and promised by the law. Section 49, I just wanted a little clarification because this speaks to who will be required to report to the police stations. And to me, it gives two categories. You have the category of shall, so you have one category, says 49, 1A, that certain categories of patients shall report to the police station, and then there are other categories where you may order based on the court order. Perhaps the AG may want to clarify that in his response. One of the issues that could be troublesome and perhaps that we need to look at and to consider is where the person can appeal the conviction. Now, of course, you want to protect the right of the offender to appeal a conviction. That is fine. But the law, the bill as it says here, appeal against conviction, section 50, notwithstanding section 49, where a sex offender has appealed his conviction, the court shall withhold making a determination on whether the sex offender shall register or report pursuant to this part, pending the completion of the appeal. Now, it means that the information cannot be registered. The alleged offender is not to report until the outcome of the appeal. And therefore, the questions really here would be, the issue of time, how long we're going to be to wait for the appeal to be heard. And really and truly, was the judiciary consulted against the backdrop of the massive backlog of cases that are currently in the appeal court? Perhaps what is the judiciary's position on this? And could this be a potential loophole for a person to delay the process of being registered? I'm just throwing that out. I'm sure that perhaps the government would have had its thoughts on this and will be able to respond to that. So the section 61 deals with exemption from registering or reporting. And there was just one question here, again, in terms of whether it will create a loophole. And I was hoping that perhaps the AG could just give one example of the circumstances which would lead to someone requesting or applying for exemption from registering or reporting.
Honourable Member, your initial speaking time has elapsed. You have an additional 15 minutes. You care to avail yourself?
Yes, thank you very much. Yes. So, Mr. Deputy Speaker, so those are just a few of the issues, as again, that we hope we'll get some clarification. As I conclude, I'll not be much longer, but I just wanted to mention that in terms of the work that was mentioned by the Attorney General in terms of the work for children in this country, that on our side, on this side here, we were responsible for the operationalization of the Children's Authority. We supported the bill against child marriage. Of course, we established a life fund very early in our term in 2010. And, we've always, our political leader, Kamala Prasad-Bisesa, has always had, dedicated to children and so on. So that goes without saying that, it really is the hallmark of a legacy. So as I close, Mr. Deputy Speaker, again, I would want to congratulate and commend the work of the committee, the Senate Select Committee, and the legal drafters, and all the stakeholders who took the time to be involved. But you say it for yourself, right? So you see, I understand why you would be wearing black today, because you're dealing with a very somber issue, so that explains that for me today. So, and I'm hoping that we'll look at the issues that raised to be clarified. And I thank you very much for the opportunity, Mr. Deputy Speaker.
Thank you.
I recognize the member for St. Joseph.
Thank you very much, Mr. Deputy Speaker. Mr. Deputy Speaker, I take the opportunity to join the debate and act to amend the Sexual Offences Act. First of all, I want to say it is refreshing to hear a first responder who actually knew the subject matter. and came prepared to debate. A refreshing change. However, my honorable friend was going very well until the last minute when he spoke about the support of the Honorable Kamala Prasad-Bissessar for the child marriage bill. Madam, Mr. Deputy Speaker, the record will show, and I don't know why the member spoiled what was an excellent presentation, unbiased, objective, nationalistic presentation with an untruth. And let me tell you what the untruth is. When the Honorable Attorney General, because it has to go on the record, when the Honorable Attorney General piloted this bill, the Child Marriage Act, in the Senate, it was under the guidance of the Honorable Kamala Prasad-Bissessar, SC, MP, former Prime Minister of the Republic of Trinidad and Tobago, who positions herself as the grandmother of Trinidad and Tobago, who saw it fit to direct her Senate bench not to support the legislation. The member of Parliament for Superior went so far as to put 2 temporary independent senators, old men of religion,
Opposition senators.
to oppose the legislation.
He's responding to the member. And we're dealing with the definition of child in section 2 of the Act.
Yes. You had to do something.
Clause 2, section 2, clause 4.
Overruled. Check your standing orders, member. Right, nice. Overruled.
If you check clause 2, section 2 of this bill, it talks about a child. I'm simply correcting the member when he said the Honorable Kamala Prasad-Bissessar supported the child marriage legislation. The honorable member did not in the Senate. And you brought in 2 old men of religion to talk for child marriage, to defend old men from statutorily raping young girls. That is the record, and you were going well. But that was the fatal error that you made. It is only when the public, when we took this issue onto the public, and we removed it 3/5, that the member for Superior saw the light of day. That is the record. I just wanted to correct that. Thank you very much, Mr. Deputy Speaker. The record has to stand. Has to stand. It is this Prime Minister who, the Honorable Dr. Keith Rowley, who came here and just like he did on Monday, put down a seminal piece of work to talk about child marriage. And that is why we have that piece of legislation. Mr. Deputy Speaker, this piece of legislation fits in with the government's National Development Strategy 2016-2030, as stated in Vision 2030, which articulates a very broad policy framework for the development and transformative reforms in our public sector administration. And it fits in brilliantly under the theme, putting people first, because that is what we are doing here today. Putting people first, and I'm going to speak directly about putting women and children first, because those are the victims, the major category of victims of crimes of a sexual nature. Yes, men can be sexually abused, yes. But by far, most perpetrators tend to be men, and most victims tend to be women and children. And it speaks to gender discrimination also. And that is what that child marriage bill was about. Mr. Deputy Speaker, the product that we have before us is a result of a special select committee, and I think I want to congratulate on this side again, Senator the Honorable Clarence Rambarat, who expertly chaired those 12 meetings, where they received extensive written submissions. There was deep collaboration and consultation. There was a combination of public sector stakeholders, civil society, NGOs, and private entities. Some of the people appearing before the Special Select Committee to demonstrate how wide and broad, deep and broad the consultations were. The Child Welfare League of Trinidad and Tobago, the Coalition Against Domestic Violence, the Organization for Abused and Battered Individuals, Caribbean Center for Human Rights, Institute for Gender and Development Studies of University of the West Indies, the Rape Crisis Society. This speaks to a very deep pathology in society when we talk about sexual crime. Women's Institution for Alternative Mediation, Trinidad and Tobago Association of Psychologists, Womantra, Vision on Mission, CAISO Sex and Gender Justice TT, and Dr. Jeffrey Edwards of MRF-TT, Medical Research Foundation of Trinidad and Tobago, who would have broadened the perspective as far as HIV and sexually transmitted diseases were concerned. I want to respond to a question posed by the member for Faisbad when he spoke about lab accreditation. Yes, important issue, and that issue is now being handled by the Ministry of Trade and Industry. There was a cabinet note some months ago that dealt with that, and all the ministries had to submit their recommendations and comments, and health would have done that. So that is in the works, under both private and public sector, yes, right? So that is something that we are looking at, actively looking at. Mr. Deputy Speaker, as I said, I am taking the view from the victim of this. And when you look globally as what is happening, I want to congratulate women around the world. Women around the world, especially women in the United States, who gave birth to, no pun intended, this Me Too movement. That was an important movement to galvanize both men and women and legislators around the world to look at the whole issue of rape, male dominance, and the victimization of women. Mr. Deputy Speaker, I met with about 4 local and 1 foreign expert on this matter 2 days ago. And I was asking them, is there a particular pathology? Is there a particular trait? Is there a particular profile of a sexual predator? You know, when we talk about sexual predators for children, we think about the dirty old men. That is a myth, a total and complete myth. What the experts are telling me, and pardon me if I just read a couple of lines here. Most persons who are abused do not themselves go on to be abusers. We tend to think that most persons who abuse will become abusers. However, the majority, that is 75%, of sexual offenders do have a history of maltreatment or abuse. So that is one trait or characteristic number 1. Most victims of sex crimes are targeted by persons known to them and not strangers. Important. Therefore, communities should be educated about sexual victimization. And what about the victims? The victims are often what? They feel they have brought this upon themselves. They suffer from shame, guilt, self-blame, post-traumatic stress, anxiety, and depression. So we have to understand one thing. There is no predictive element to say who will be a predator. It could be anybody. So the pathology of the sexual offender is not definitive. It is not the dirty old man. But there are some traits. And what are some of these traits? 1, social and interpersonal and intimacy deficits. Victim empathy deficits. They don't feel sorry for their victims. Victim empathy deficit. Cognitive distortions, poor coping and self-management skills, and under-detected deviant sexual behaviors, and a history of maltreatment. And more males are prone to be offenders. This whole issue of the male machismo. Does physical strength play a part in it? I asked all the experts. Couldn't come up with a definite answer. But however, persons who commit one, the experts agree, there's a 17% rate of reoffending. And that's important to know. A 17% rate of reoffending. Mr. Deputy Speaker, in putting a plug for women and to show how society is so biased against women, I want to quote, and I hope my friends opposite will allow me, and you, Mr. Deputy Speaker, a pretty long paragraph to put on the Hansard. And I think it's important, and if colleagues will allow me. Sir Matthew Hale's Historia Placitorum Corodi, written in 1760, he said this about the impossibility of marital rape under English common law. 1760, and he said this, and I quote for the Hansard. The husband cannot be guilty of a rape committed by himself upon his lawful wife, for by their mutual matrimonial consent and contract, the wife hath given herself up to her husband, consent which she cannot retract. All of us know if you don't give consent, you are guilty of rape. He is saying, because of marriage, consent cannot be retracted. A wife had given her body to her husband and also gave irrevocable consent to sexual intercourse with her husband. That was the law for 231 years, up until a seminal case, RVR, in the House of Lords, 1991, which the English common law then recognized that marital rape is in fact a crime. And that is what women had to live with for centuries. And in some cultures today, it still exists. So these laws that the Attorney General is bringing, child marriage, operationalization of the children's courts, the family courts, the DNA, all of this is righting historical wrongs against women that have been perpetrated under this banner of law, as said by Sir Matthew Hale. We men should hang our heads in shame and say sorry to women. And I say sorry to women for this. So now you can be convicted of marital rape. And this law takes this whole conversation even further. Mr. Deputy Speaker, I want to touch on the issue of the register because the member for Faizabad spoke about it. Yes, our register is not going to be open to the public, correct, AG? Correct. Under certain due process.
Unless the court permits,
right.
Under Section 54.
But this is separate and distinct as to what happens in the United States. In the United States, under something called Megan's Law, written after somebody called Megan Kanker, it is actually the federal law mandates that states do make some of this information publicly available, but we are not going that way as yet. As you said, let us see how the law is applied, let us see how the law evolves. But it is an important step because, as you said, since 2000, we have had the register, but we have not used it. And Attorney General, you are to be congratulated for coming to this Parliament, to go into the Senate, to finally do something about a piece of legislation which we have had to protect women and just simply not used it. Congratulations to you, sir. Congratulations to you, sir. Mr. Deputy Speaker, the last item I want to touch on, and this is for parents and children, is the whole issue of how online predators work. The dark web. This did not exist when we were children. This did not exist. It poses a real threat. The internet, computer technology. And there's a very good website about how online predators work and which young people are at risk. One of the takeaway points here is that young people feel they are not vulnerable. Young people feel that they have all the answers. This article clearly says no. Young people are actually naive when it comes to these things. But it's up to parents. It is up to parents to take a handle on it. So which young people are at risk? One, young adolescents are the most vulnerable age group and are at high risk of being approached by online predators. Why? Because young people start to explore their sexuality. We used to explore our sexuality a long time by going to party. Now they are doing it on the internet, in the privacy of their home, with a camera. No one can see them. When we go to a party a long time and rent a tile, everybody's seeing you. You should go on as well? I used to bounce up and stuff on the parties, you know. Right? So young people are very, very vulnerable to online predators. Mr. Deputy Speaker, parents have to be armed with the tools to minimize the risks of their child becoming a victim of online predatory behavior. So what are some of the things that a parent can look out for? Because this is important. Parents need to monitor their children's use of the internet. One, if you see your child or teen spending a lot of time on the net, hours upon hours upon hours, chances are they are starting to look at these sites. Two, go onto your family computer, parents, and see if you're seeing porn. Look at it. Start to see if your child is starting to receive phone calls, either through their cell phone or your landline, and a normal rise in phone calls. It means now that the online predator is now making contact with that child on their phones. See if your child starts to receive mail or gifts, unannounced gifts. All of a sudden, a teddy bear appears, or whatever appears, a pair of shoes, a pair of jeans, technology, underwear, a new phone. Start to monitor these things. Start to see, especially if your child starts to withdraw from family gatherings and start to go into a shell. If your child starts to display these characteristics, chances are they are being groomed. Chances are they are being groomed. And finally, check to see if your child is using somebody else's account to mask or hide what they are doing on the internet. So, Mr. Deputy Speaker, I am not going to be very long today. I think what we are doing here is important work. I want to congratulate the Honorable Attorney General again, once again, for coming with another piece of landmark legislation. I get the impression that the opposition is going to support the bill, and for that reason, I don't want to delay proceedings, but thank the opposition for their support, and thank you very much, Mr. Deputy Speaker, for the few minutes that you have allowed me. Thank you very much.
I recognize the member for Couva North.
Thank you, Mr. Deputy Speaker. And I'll get right into it. Mr. Deputy Speaker, the Member of Parliament for St. Joseph said that my colleague from Faizabad ended off bad. But I want to say to him that he started bad and continued in that bad trend. And why I say that, Mr. Deputy Speaker, is that the member for St. Joseph is splitting hairs because his statements on the Senate not supporting the child marriage bill, as a member of the lower house, why didn't he not mention that we supported here in the lower house the child marriage bill? Why didn't he say that? But mischief, Mr. Deputy Speaker, this is the intention of St. Joseph, to create mischief. We were going well before, and that's why I said he started bad. Mr. Deputy Speaker, again, the member for St. Joseph spoke about crimes against women perpetrated and how he feels sorry for them, being very, very apologetic on behalf of women in Trinidad and Tobago. But I want to ask him something today, Mr. Deputy Speaker. How do you feel about your colleague from Diego Martin Central? Do you feel the same way? And why have you not proffered to tell us where is the report that has been pending for so long? Mr. Deputy Speaker, I want to say,
I rise on Standing Order 48.4 and 48.6. There has been no determination on any issue to have pronounced in the way the member just did.
Oh, really? Oh, really? I asked her.
Overruled.
Thank you.
But member, right, even though I've overruled, again, I want you to tie it in very quickly to the point.
Very
right?
quickly.
She's responding.
Quickly. Right.
Mr. Deputy Speaker, I'm responding to the member.
Member for Couva South, I heard, could you get up and just retract and apologize?
I retract, Mr. Deputy Speaker.
No, I would like you to apologize also.
I am apologizing, Mr. Deputy Speaker.
Thank you, Mr. Deputy Speaker.
Member for Laventil West. Member for Laventil West. Proceed.
Thank you, Mr. Deputy Speaker. So I was just responding to the member for St. Joseph who has shown his apologetic side to the women of Trinidad and Tobago, and to say that he's been extremely hypocritical when it is you have a sitting member of Parliament, Diego Martin Central, a report pending, and of course we have seen all of the newspaper reports on the incident which took place, and we are waiting this. So if you really, truly feel sorry for the women of Trinidad and Tobago, you would make that report public and share it with us here in the Parliament.
Standing Order 48.6, Mr.
And you
Deputy
get the correct
Speaker.
picture, Linda
And if I
Babulal.
may elucidate, if you wish, this is a far-reaching conclusion on the part of the member as to a matter concerning a member of this House, Mr. Deputy Speaker. The proper way to bring this is by way of a substantive motion on the member, but to introduce it into the context of this debate is entirely improper within the standing orders, particularly 48.6.
Yes, okay. And member, I think you have made the point. Let's move on at this time, please.
Thank you, Mr. Deputy Speaker. I think I've made my point. So, Mr. Deputy Speaker, let me get into my contribution. And in passing, I want to say that the Attorney General, in his introduction of this bill, mentioned that it may be possible at some point in time after due course that the sex offenders registry can be made public, and I want to say that is a good intention as of now. In addition to that, Mr. Deputy Speaker, however, he was a little bit disingenuous, the Attorney General, when he spoke about the work that his government did with respect and is doing with respect to the protection of the rights of the child. And I want to remind him that it was the former People's Partnership government under the leadership of Kamala Prasad Bisasa, and don't roll your eyes, AG, come on, you know it's true, that introduced the Children's Bill in 2012. We started the ball rolling. And I want to remind him also that in May of 2015, we launched the Child Protection Unit of Trinidad and Tobago. So my job as an opposition member is to remind him of the work that the former government did, and to remind him also to not negate the hard work of past governments. Mr. Deputy Speaker, since I'm on the Child Protection Unit, let me go ahead to say that in my little bit of research over the past couple of days, the Child Protection Unit, AG, I want to say from my research and my gatherings, that they are still woefully understaffed and they are very much overworked. The officers at the Child Protection Unit, and therefore I'm making an appeal on behalf of the Child Protection Unit for you to fully staff all of the divisions of the Child Protection Unit. There are 9 divisions, Mr. Deputy Speaker. These are the men and women who are in charge of bringing in the perpetrators. They're in charge of investigations. They're in charge of bringing in the perpetrators of sexual offenses against the child. And therefore, I am making an appeal on their behalf. What I also understand, Mr. Deputy Speaker, is that the head of the Child Protection Unit, there seems to be no stability because there's always changes with respect to the head of the Child Protection Unit. And you need some sort of stability when it comes to leadership of that unit, and therefore I want to make a second appeal to look to stabilize the operations of the Child Protection Unit by having a lead or a head there who can stay a substantial length of time so that they can lead the officers to do their good job. Mr. Deputy Speaker, in addition to that, I also want to remind the Attorney General that in 2010, the Ministry of Gender, Youth and Child Development was formed and created under the former government. And this particular ministry, under which I was very fortunate to serve as Minister of State for a year, in that particular ministry, it was solely dedicated to dealing with the vulnerable in our society, meaning that of women and children, and trying to deal and work and bring together plans and policies that would see our women and children better protected. And I also want to say to the government that they have continued some of our work, not most of it, but some of our work. And today here in this House, this bill is one of such. And therefore, yes, we are in agreement in agreeing on this bill, dealing with this bill. I mean, it was said before by my colleague from Faizabad, this bill is very much important, Mr. Deputy Speaker, in moving forward, and we are in support of it. Mr. Deputy Speaker, in continuing, let me also say that from the statistics the Attorney General read, we have seen and we have witnessed also from news media reports out there that there have been a huge increase in sexual offenses against a child over the years. And then again, as a previous government, that is why we would have come together to have this ministry created, to lay the Children's Bill in 2012, to launch the Child Protection Unit in 2015, and for this government to continue our good work. Mr. Deputy Speaker, in addition to that, you know, it's really, as my colleague from St. Joseph mentioned in his apologetic stance here today, that it is never enough in terms of protection in dealing with our women and children, because he introduced something at the end of his contribution, which is the advent of online offenses and predators being online and luring your children. And these are things that has developed because we are now in an age much different from before. And these are new things that the government will have to deal with and new issues that we would have to deal with. But as parents, what we can do in our own way and in our own little homes is to caution, to be extremely vigilant where our children are concerned in terms of how they utilize the internet, the hours that they spend on their devices. I know that there's a mechanism where you can copy your kids or a phone onto yours and you see the messages that are going through. You are able to look and see what your child is up to. I mean, I have that mechanism where I'm able to monitor. And yes, I have a 12-year-old stepdaughter, yes. Yes. So we are able to monitor what is happening. And I'm able as a parent, and many parents, because when you are a parent and you are within that fraternity, you are able to share ideas with other groups, and this is one mechanism by which parents can implement to monitor their child on the internet, and it's very, very useful. So, Mr. Deputy Speaker, over the years, we would have seen some really heinous crimes against our children. And I just, you know, in passing, want to mention Akil Chambers, Sean Luke, Amy Anamontudo. Those crimes hit us very hard as a population, Mr. Deputy Speaker. And because of that, I think all of us as public officers were propelled or are propelled to do more for our children. And therefore, at the end of the day, Mr. Deputy Speaker, this issue that we are dealing with here today goes beyond political lines. This is about the nation's interests at the end of the day. This is about our future, developing our children for the future and protecting the rights of the child as we go forward. Now, Mr. Deputy Speaker, I was happy to see that the harmonization of the ages, where it is clause 5 and 6 of the bill seeks to harmonize the age of the child. And the issue of protecting the rights of the child also would have started also under our former government, where we had started to partner with NIDCO in terms of infrastructural development. So when we came into office in 2010, between 2010 and 2015, we identified that there were a lack of homes for our battered women, for our children who were victims of sexual crimes, and therefore we partnered with NIDCO at that point in time to come up with some projects to extend and to develop on the infrastructure that we have in Trinidad and Tobago in dealing with this. So we would have introduced the transition home model. We would have also looked at expanding and building shelters. I know that one such home was opened in Chaguanas not too long ago by the goodly minister from Tobago East, Minister Ayanna Webster Roy. And that would have been a project that had started under us. And therefore, it is also about making sure that the resources are there to accommodate for these legislation and for these pieces of legislation that we lay here. Mr. Deputy Speaker, in addition to that, I would want to know from the Attorney General, whoever is responding to me afterwards, what became of these projects, the infrastructural development projects that we would have had in train. What became of that? How many were completed? How many were stopped? Or if they did continue at all with the transition home? I'm very much interested in the transition home and the home for battered women. I know that there would have also been a partnership between existing NGOs who already are working in these areas to expand the complement or expand their spaces to allow for more victims to be part of that system. So I would really like to hear about that because, you know, laying legislation and passing legislation is all well and good. But then when you go down to the ground and you have to actually implement and make it workable, it's a different thing altogether. And sometimes it takes years and years to implement. And therefore, it's very important to know where we're going with respect to this, especially when it comes to the protection of children and women. Now, Mr. Deputy Speaker, I also want to mention that in section, and I think my colleague from Faizabad mentioned it earlier on, but I would like to just go into a little bit. And so it's part 3, and it is section 30. Okay, right, yes. It is this area where section 42.1, where the results of a medical examination of a person referred to in section 37.1 reveals that the person examined has a sexually transmitted infection. Information to that effect shall be immediately communicated to the person, the virtual complainant, a representative, where the virtual complainant is a child, and the complainant. And I want to say that this is a very, very good move on behalf of all. And I know that MP for Faizabad in his capacity as a doctor would have come across many cases where in some instances children, they come for tests, they come, you know, for their checkups, and before you know it, something pops up and questions arise. And it's very, very important when these processes are put into place that there is a mechanism where it just doesn't end right there. And you know, people in Trinidad, we have a culture where we are afraid to talk, we are afraid to share information. But in dealing with children, where after a medical examination is found to be, let's just say, HIV infected, that this information goes to all concerned. And I'm very happy that in the bill it is explicitly stated so that there can be provisions put into place afterward to deal with the situation. And as MPs, as we sit in our constituency offices, we get issues like this on a regular basis, where it is we have persons coming to our office, mothers, single mothers, sometimes, you know, grandmothers, relatives, and they come to you and they give you a story of abuse of their young ones, of their grandchildren, and then they tell you, well, you know, I took him or her to the doctor and we realized that, you know, they've been infected or, you know, that kind of thing. And it's very, very sad. And how do you help these cases? How do you really help these cases? How do you put into the minds of a young girl or a young boy at such vulnerable ages that this is what you are to, this is what you have, and this is what you have to deal with for the rest of your life? So what mechanisms are in place? And what is government doing in terms of expanding the resources for cases like these? And I know that my colleague from Tobago East intends to speak, and I would like to hear what is in place for that. Because it's a very, first of all, it's an expensive situation dealing with in the aftermath. Very expensive. Medical care, is it that through the Ministry of Social Development that we are going to have some sort of funding or provision made to assist these families who come forward and who say, well, look, my child was raped, my grandchild was raped, she or he now has HIV, and we need some assistance? Because I know that apart from the work by the Child Protection Unit and by Children's Authority, sometimes cases fall on the wayside. Because I have had interaction with the Children's Authority, the Child Protection Unit, for many issues, similar issues as to what I'm referring to. And over time, these cases fall to the wayside, and parents and families have to get together and try to see how they can pool their resources to help their very own. And, you know, the mechanism of the state fails them at the end of the day. And this is something that we need to address and to ensure that there's sustainable assistance as they grow. So that is something that I wanted to flag and to say that I'm very heartened to see that an additional step is being made. Again, I want to mention that the Attorney General, what he said about the registry being made public, and at this time we understand that the database for sexual offenders will be held under the purview of the Commissioner of Police, and it's all explained here in detail also. The reporting mechanism also of sexual offenders coming into our country seems to be also very detailed, and I hope that the mechanism of monitoring in terms of those sexual offenders having to report to the police stations and all of that, that particular monitoring mechanism is always in place, because we can't afford, I mean, we are right here within our locality here in Trinidad and Tobago. You know, we are not very able to deal with the sexual offenders that we have here at this point in time, and therefore those persons coming in from other countries, regionally, internationally, the monitoring aspect of and the reporting mechanism to the TTPS needs to be very much tightened, and a better control system needs to be implemented. So one would hope that in time this can be developed also. Mr. Deputy Speaker, in addition to that, and my colleague mentioned it earlier, so I don't want to repeat, but I also want to refer to Section 55, again with the reporting mechanism ordered by the court. Section 55(1), 2, 3, all deals with that in detail. 56(1), the reporting period of a registered sex offender on whom a sentence specified in Schedule 5 was imposed shall be, for a registrable offense, shall be the corresponding period specified in the second column. All right, so that went on to really just put into train the reporting mechanism. As I say, it's very detailed, and we look to see the workings of that and to ensure that it works in the best interest of our people. Mr. Deputy Speaker, in addition to that, Section 59(1), where a registered sex offender who resides in Trinidad and Tobago intends to travel outside, he shall at least, during 7 calendar days before his departure, report to the police station nearest to his main or secondary address and provide a designated officer with the following information: the date of his departure, the countries of his intended stay, and any country through which he may transit, and there are other provisions and conditionalities attached to that. I think that is very, very important also, because many a time when you look at news, and sometimes, you know, CNN or whatever station we decide to look at, sometimes you see news on Trinidad and Tobago nationals and crimes that they are committed or have committed abroad. And sometimes some of these crimes are sexual offenses against a child, murder of a woman, and in most cases, Mr. Deputy Speaker, it is not their first time offense. And therefore, it is very important that when they travel, that they are, of course, informed. And it's also disheartening, Mr. Deputy Speaker, at times to see that our citizens of Trinidad and Tobago, you know, sometimes you go abroad and it's always besides going for a holiday, but in most cases where they settle, and to see these types of activities continue to be perpetrated across there. And it says something about our mental wellness and our well-being. I know not too long ago, a couple of years ago, the member for Sawa Barataria spoke about the increasing numbers of persons in Trinidad and Tobago who suffers from mental illness. And he called for something to be done about it at that point in time. And whilst the AG spoke about an analysis being done with respect to those, or to identify those perpetrators who have mental illnesses, I think that it is something, and the Minister of Health also, who's listening, I think that it is something bigger than that. I think that really, as the member for Sawa Barataria mentioned, that it is something that has increased over the years, and we need to look at the psyche of our population and see how best we can help in determining mental disorders, illness, well-being, you know, so that we can have a better and a healthier population. Because the men and the women who perpetrate these crimes, they are not reasonable individuals. They are not well. And as much as some may argue in their defense in cases of a one-time offense, I firmly believe that if you do it once, you're going to do it a second time, a third time, and a fourth time. And therefore, mechanisms need to be put into place to deal with these predators. And as much as there are provisions within this bill that allows, I think after 25, is it 25 years? Or allow after a certain period of time, the AG will correct me when he winds up. But where a provision allows after a lengthy period of time for that person not to go on to the registry, I really want to urge that that particular aspect be rethought. Because again, as I said, I believe that once you do it, and you do it for a first time, that there's always room, and I believe that individual will do it again regardless. So, Mr. Deputy Speaker, in addition to that, I must say that as a population, we have come a very long way with the protection of the rights of our child in dealing with sexual offenses, abuse, crimes against our women. I mean, there's so much more we can do, but we are on that path of improving the well-being and the environment within which our children and our women exist. And therefore, it is quite, again, as I must say, disingenuous when the Attorney General came here and only mentioned what his government was doing and disregarded what the former government and even governments before would have done. I want to commend all of the NGOs of Trinidad and Tobago, all of the stakeholders who came together. My colleague from Princestown, when he brought the report, it was quite thick and very much, yes, very much, a lot of work. You could have seen a lot of work went into that. I want to commend our members also on the committee who put out the hard work in getting some of the changes that we now see here in this bill. And Mr. Deputy Speaker, as a mother of three, I want to say that personally I will continue to do what I can within my capacity to help those victims, women and children, and to continue to work in the best interest of the vulnerable in Trinidad and Tobago. Thank you very much.
Honourable members, it is now 4:28:34. Could I have the consensus of the Leader of the House and Chief Whip that we can suspend for tea at this time? Yes. Right? So, yes, nice. Okay, so honourable members, we will suspend for tea and we'll resume at 5 p.m.